Yes.
May I please your lordship? My lord, day before yesterday, my lord, I have filed a petition, my lord.
Yes.
Mention.
You mention later.
Mention.
Wait for some time.
Adjournment request, if any, from item number 1 to 7. From item number 1 to 7, adjournment request. From item number 8 to 13. From item number 14 to 26, adjournment request.
Lordship, I'd like you to request you to adjourn item number 20 and fix another date.
20.
Yes, Your Lordship.
Why?
My senior is unwell.
A prayer for adjournment has been made on behalf of the appellant on the ground of indisposition of the learned advocate who is to address this court. Let this matter come up for consideration on. Give a date in January.
28 January.
Oblige, Your Lordship.
Wait. From item number 28 to 35, adjournment request. No. Any other request?
May I please your lordship? My lord, I have filed a petition, my lord, day before yesterday, my lord, on 17th, my lord, challenging the Land Acquisition Act of 1964, my lord. My lord, in this matter, my lord, there are three petitions pending.
Challenging the Land Acquisition Act of 1964.
64 Assam Act. And my lord, what happened, my lord? Three other petitions were filed on the same and similar facts, my lord. This honorable court had admitted and fixed on 27/11, my lord, all the three matters. Admitted, my lord, stay interim is granted. My lord, my lord, what happened? I had filed a petition, my lord, and I mentioned it that it is so and so, my lord, pending before the division bench the issue. So maybe may not be taken now, but day before yesterday, my lord, some order is passed, my lord, yet not been uploaded, my lord. Although I was out of station because of some bereavement, my lord. In absence of me, my lord, some order is passed.
It's not fair on your part to now mention it without looking at the order.
My lord, that is my lord. What happened? It is I have not challenged it there, my lord. So this
You may
order
not
is-
be challenging, but you have the order before you, and then tell us what has happened. We will have it listed along with the other matters, but don't mention like this.
my lord.
This
What,
would be misleading.
my lord, no, my lord. Whatever I'm praying.
That's right. So we are not taking exception to what you're mentioning, but then
My lord, I'm nothing hiding, my lord. I'm
Mr. Counsel, you have to be careful. We are only saying this. You're not hiding, right? You only said that some order has been passed.
My lord.
Let us see what order has been
My
passed.
lord, what is
I have
the,
a copy of that order tomorrow.
my lord? What
I'll
is the
make a
urgent?
mention
What is
tomorrow.
the urgency, my lord? That today they may be there.
Whatever is the urgency, unless we know what is the order, we will not pass any order.
My lord, today we may be evicted, my lord. That is what the.
We can't help it.
My lord.
You please get hold of the order. The order shall be supplied to you. You can always obtain that order. Then come back to us tomorrow.
Tomorrow, my lord.
Don't show that urgency which is not there.
My lord, today we may be evicted, my lord. That is the thing.
What can be done? Tell me one thing. You go out of station when the matter is listed, and then some order has been passed by a single
My
judge.
lord, my elder
How
sister,
do we avoid that order?
my lord, at 11:30, my lord, my elder sister died, my lord. Should I not go to my home immediately, my lord?
What
lord,
I
that-
am
that-
saying, what you are responding. Try and
That's why, my lord. That's why I could not appear, my lord.
Please behave like an advocate. Have I said that? Why did you not appear? I said it's your fault. But then, unless we see the order, can we ask for
Yes.
tagging of that case?
Yes, my lord.
I have given you the liberty.
Oblige.
Get rid of the order. Come back to us tomorrow. We will see if something can be done to stop that eviction or whatever.
My
We
lord.
will do that.
My lord, may I be allowed to, if the order is, my lord, online, my lord, can I come at 2 p.m., my
No.
lord? Because it's urgency is only, they
No.
may demolish all the.
Come tomorrow.
Oblige, your lord.
My lord, pray for listing for an admission item tomorrow, my lord. In fact, we challenged the entire DP based on bias, my lord. The honorable single judge, my lord, had partly allowed the writ petition, remanding the matter back to the stage of cross-examination. There's material on record to show that the inquiry officer had gone beyond the mandate of the rules and had recommended my dismissal, which was also accepted by the inquiry.
That's all right. So matter has been remanded.
My lord,
So
We want the
what
matter to be
prob-
remanded
what
the whole
problem
hog.
You have with the order of remand.
My lord, we expect the order, the process to be remanded the whole hog, my lord, to the entire initiation of the
Doesn't
proceeding. My lord,
matter.
we have,
You have challenged it, we'll see.
my lord,
No
tomorrow.
urgency. At an appropriate time with its maturity. Sometimes in the month of December.
May I please, Lord?
Give a date in December.
May I please? I make to mention for listing, my lord.
What is it? No, we don't. There's no urgency.
May I
There's no-
please, Lord?
Yes,
I beg to mention for listing, my lord. I have filed a contempt petition on 6th November, but till today it is not listed, my lord.
why?
Kindly.
It has to be listed. Any day. Any day next week.
Obvious, my lord.
Your, I have filed a PIL yesterday regarding the issues of amendment of the private university act, Your Lordship.
I didn't hear you. What is it?
I have filed a PIL yesterday regarding challenging the issues of PIL. Sorry, Your Lordship, I have been resting, so.
Hold your breath and then. Yes, ma'am.
I have challenging the amendment act of private university act, Your Lordship, 2025.
Amendment Act of Private University.
Yes, Your Lordship.
On what grounds?
Uh,
And that's a PIL.
Yes.
Okay.
If possible, then kindly be listed by tomorrow.
No,
or the
but
afternoon.
on what grounds have you said that? Because of the urgency. If the matter is urgent, we'll have it listed even today. I mean, there's
I
no
have
problem.
pointed out 21 different points, grounds regarding that issue, Your Lordship. It has been thoroughly discussed.
Now, but what is the urgency?
Actually, it is depending upon the life of the various
When was the amendment carried out?
The amendment carried out on merely on 3 different grounds, Your Lordship. I may be allowed to highlight certain points.
Anyway, we will not have it listed tomorrow. It will be sometimes in January. January, all right. Yes,
Daily list for orders, item 1.
no steps for our sake. Yes,
Lordship, there is a office note is there. I have deposited the amount. And the
All right.
office note says where to, amount has already been credited to the Registrar General.
take down. By order dated 23/6/2008, this case has come at the instance of the office, at the instance of the registry. Next panel. A division bench of this court, by order dated 23/6/2008, had dismissed this appeal and had also imposed cost of rupees 10,000 to be paid by the appellant, but without intimating as to who would be paid. In compliance of the order, a draft of rupees 10,000 was deposited by the appellant, which with the passage of time expired. On the request of the registry, the draft was revalidated, which is presently lying with the High Court Treasury. Since there is no stipulation in the order as to who shall be paid that amount, the amount shall remain in the account of the Registrar General of the High Court. With this clarification, the records are consigned.
Item number 2.
No.
Wait, please.
On number 6,
Yes.
what is the report? Report that what is. Why has it come for orders?
Well, steps has already been taken. Everything. I have also filed the reply in
Why has it come for orders? Let this case be listed for admission on so and so date in December.
December. Item 3,
Adjournment slip.
adjournments.
An adjournment slip has been circulated with the consent of the other side. Let this matter be listed on this one.
16 December. Item 4,
May it please your lordship. My lord, in item number 4, my lord, we are no longer representing the clients. They have taken the NOC from us on 8/5/25. My lord. Your lordship, once we can file an IA, withdrawing our wakalat number. My lord.
You have filed an IA.
No, my lord, we will file it.
Taken. What is your name?
My lord, K. Mohammed,
Mr. K. Mohammed, learned advocate. Your K. Mohammed.
my lord.
Mr. K. Mohammed, learned advocate, submits that he has given no objection to the appellant in this matter. So he shall be filing an interlocutory application seeking expunction of his name from the array of the advocates representing the appellant. So even otherwise, the notices to there is no report regarding service of notice to most of the respondents. Let this matter come up for consideration along with the IA
My lord.
to be filed by the lawyer for the by the learned advocate for the appellant
I'm deeply.
on so and so date.
18/12. Item number 5,
What has happened in review?
Well, the
You
notice
just
was-
file a review.
Yes, my notice was issued, my lord.
Notice has been issued in the
Yeah.
condemnation petition
Yes, my lord. Thereafter, it has not been listed, my lord, till date.
as prayed for. on
My
behalf-
lord, petitioner is suffering from blood cancer, my lord. He is now under leave, my lord. Without money, he is unable to, my lord.
I am only giving you a long rope till December. By that time, if you don't get an order, then perhaps you'll have to comply with the order.
Yeah.
It'll be subject to the decision and review
Yes, my lord.
as prayed for on behalf of the respondent. Re-notify on so and so date. It's 1st of January, first week of January, whichever date the court reopens.
Oblige, lord.
5th January. Item number 6,
Maybe. The opinion dated 23/5/2025, madam, neither AD got not answered notice in respect to respondent number 3 has been received.
Respond, you're for respondent number
I'm
three.
for respondent number 2, my lord.
Who appears for respondent number 3?
Notice is
Not
not
yet,
served,
yeah.
my lord.
Yeah, what is the service report?
I'll take face history, my lord.
Awaiting the service of notice. On respondent number 3, the matter is adjourned. December. 31 days we are condoning, just inform if you happen to
15
know
December.
the respondent number 3.
15 December. Item 7,
It has to be, there is an impediment. You don't know. Mr. Counsel, my brother has some difficulty in entertaining any application in this petition. He hails from that district. Let this case go out. To my understanding, there should not be any problem. It's an application for impediment.
Yes.
But then,
Of course, it is his lordship prerogative, but I don't think it should have any problem.
no, forget. If he doesn't want, let it go. Let this case go out of our list and be listed before an appropriate bench of which one of us Arun Chaudhary J.
Religious institution,
And that's all.
which is referred by.
Let's not have any discussion in detail when one of the judges would not like to hear it.
I'm not saying.
That's right. And one of us, bracket Justice Arun Dev Chaudhary.
But in the name of religion also, my lord, the discrimination is also prohibited. my lord.
Chief Justice for allocating an appropriate bench. Okay. General order
Item number 8.
has come in feet. I was going to.
May I please, Your Lordship? My lord,
Respond number 1 to 5.
my lord, this substitution may be allowed, my lord. On 3 occasions, my lord, the service have been awaited, my lord. The wife, my lord, of the deceased. May I pray, my lord, the substitution may be allowed, my lord.
Substitution we will allow.
Yes,
Which is that application?
IA, my lord, 2716.
Two one seven. This is an application, IA number 2176 of 2035. This is an application seeking impleadment of Srimati Mai Prondi Long Mailai, wife of late Domon Long Mailai, who had instituted the writ petition. The original writ petitioner died on 29/5/2025 due to kidney disease. The wife of the original petitioner seeks impleadment for contesting the matter in the contempt petition C case number 641 of 2020. For the reason stated in the application, we allow the impleadment of the substitution of so and so in place of the original writ petition.
My lord,
The
wife and son, my lord.
Wife and son also.
Yes.
And son, वो दोनों लिख देना. Wife and son, details, name. A fresh memo of parties be filed by the substituted petitioners in the registry within a period of 1 week.
My lord, the main case may be listed after 2 weeks.
Let the contempt case be listed in the month of February. In the month of February on so and so.
Obliged.
4th February.
Obliged.
Item number 9.
Your Lordship, I can move pass over for time being.
You want?
Time being, for time being.
For the time being, we don't do it. Considering the board, this prayer is rejected. Either you argue or it goes on another date. No Passover normally. Day after tomorrow?
Yes, Your Lordship.
Day after tomorrow. As prayed for on behalf of the petitioner, as prayed for on behalf of the applicant. This is applicant, no? On behalf of the applicant, re-notify on so and so day.
21/11. Item number 10.
But the IA is for the condemnation of the delay, my lord. There is delay of 57 days.
All are Union of India, all respondents.
Yes.
Heard so and so, we are condoning the delay. The delay is condoned, the appeal to be processed. Take the names and the reason given.
2nd February. For admission, item 11.
Yes,
Lord, I'm praying for an short adjournment, my lord.
Mr. Bhuyan, I'm watching this. You never argue on the date when the matter is fixed.
No, my lord, actually, last,
Why did you not ask for adjournment in the beginning?
Lord, my learned friend, I could not inform him, my lord. That's why, my lord. Some personal medical difficulty, I could not prepare, my lord.
Medical difficulty, we shall. You want it tomorrow, day after tomorrow, when?
Any date, my lord. That is because he has already taken over the charge.
He has taken over the charge.
My lord.
Yes. He has a good ground. He has a good ground. Okay. It is not always the case. Anyway,
My lord.
this is again, you have accepted it as fait accompli.
My lord.
But then you have a case, Mr. Bhuyan.
Right.
Take care. At the request of Mr. Bhuyan, learned advocate for the appellant, The matter is adjourned to January.
March oblige, madam.
8 January. Item 12,
Yes,
24 local people were involved during the inquiry.
mask on, we can't hear you properly.
Come on.
No, you can keep the mask on.
No, it's okay. 24 people, 8 people has objected to the opening of the wine shop, which is natural, my lord. We can't have 10% in favor of opening a IMFL shop. But the learned single just thought that even if one local person object, then you can't run this business.
That's all
Well,
right. What does the rule say?
Rule, my lord, it says there has to be a local inquiry,
There has to be
a local inquiry.
local
Your-
inquiry.
Yes, ma'am. Your
Let's have
lordship
the
will kindly
rules.
take the Assam exercise. এখন pick up bro. Rule 295. 295. Assam Excise Act, Rule
But
295.
inquiry was conducted, no?
Yes. Balada.
Out of 24 occupiers of that area, 6 had objected.
Yes, ma'am. Which is natural, my lord, in any wine shop, there cannot be 100%, you cannot have. I have given the report from 22, I am running the shop. There is no complaint that there is a nuisance in that area, no police case, nothing. And there is another wine shop in that area to which they have not objected. It's only they have selectively targeted my wine shop. That's the annual of. And there was an interim order operating. There was an observation of this honorable court in one of the dispose of matter that I have complied with all the license requirement. Earlier also we came, the learned single judge disposed of the petition saying that we have complied with all the rules. I can
There
show,
shouldn't be 2 IMFL shops in a place.
my lord.
There should not be 2 IMFL shops in a place.
My lord, in Guwahati, there are 500 IMFL shops and liquors. Har gali mein, you could only
If you don't comply, perhaps your license will be cancelled.
no, that is not. My lord, they are,
I think the better option is to accept this order.
my lord, your lordship-
Relocate.
Ah.
This comes in res commercium.
that
You
is.
don't have a
that is
vested
your
right
lordship.
to open a shop at a particular place. You're a licensee, that's all right.
Yes.
Relocate it to some other place.
My lord, I have been operating in this area from 2022. Your lordship will kindly see one observation of the learned single judge in the
Now,
earlier round.
if in inquiry, it would have been found that those 6 persons wanted, bottles of liquor from you with on lesser cost, which you did not allow.
That is
then-
normally,
Then perhaps something could have been
my
done.
lord, that is what normally
But how do
happens.
we know it?
That is what normally happens, my lord. My lord, that's why,
Or they would have wanted to have your shop opened after the shop hours in the night,
No,
which you
they-
did not oblige. Therefore, the 6 persons are opposed.
yeah. My lord, I can only quote, my lord, I can only quote a couplet from Galit, my lord. It says, my lord, with your lordship's permission, शराब पीने दो मस्जिद में बैठकर या वो जगह बताओ जहां खुदा नहीं. Then to this Iqbal, my lord, he says, मस्जिद खुदा का घर है, पीने की जगह नहीं. काफिर के दिल में जा वहां खुदा नहीं. Then man come Faiz. Faiz says, my lord,
How many couplets would you speak?
my lord,
The one
काफिर
was
के
good enough.
my lord, ultimately he says that you go to Jannat where there will be no objection. Then the Sakhi said, my lord, Jannat में तो हर सुकून है, वहाँ पीने का मजा ही क्या है? So, my lord, these are people, my lord, where I have to oblige to them. As your lordship has said, I have to give them discounted price of liquor. And there are observation of this honorable court by the learned single judge of coordinate
The
bench.
order of
that-
the learned single judge is not perverse. Why do
My lord,
why do we object to it?
No, my lord, if this order remains, my lord, then my lord, earlier also what has happened, they said that there cannot be any educational institution, hospitals, nursing home within 50 meters at that particular point of time.
Yeah.
And Because this, your lordship will examine because this will have far-reaching consequences on the IMF, because all the IMF
Have you
shops.
shifted your shop or not?
No, it's not, Malad, because
Then.
we have filed this immediately. Malad, your lordship will examine this issue. Malad, one wine shop in that area will not make heavens fall for the excise department. There is no complaint. Malad. If there was any complaint that I have created nuisance in the area, I have opened beyond the opening time, there is no allegations, only this 6. And you cannot have a 100% consensus of the local people to open a wine shop.
My lords,
So
no
you
doubt,
have been running a liquor shop. You're a licensee since 2000,
One.
but in 2001, but
Yes.
in this, but
From
in this area, you
2022.
started from 2022.
Yes, my lord. And in 11 November, it was, the learned single judge says that even if there is one objection under 295, I can allow you to. But then entire shops in Assam, nobody will be open to open an IMFL shop, my lord. If that's the ratio laid down in terms of 295, my lord. So I can access.
exactly, my lord, that will dilute the act and the control over the controlled business, my lord.
If you say that. And my lord, before the inquiry also, there is another procedure your lordship will see 289(1).
And my lord, the learned single just though confine himself to this logic, there are some other grounds also, my lord.
289(1) may also be seen.
Page? This is what document? There will be an increase of criminals if we end there for the mathematical. No, yeah, translation to keep it. Okay. Take it down.
Your, just a moment, your lordship will post
Just
it
a
in.
minute.
My lord,
Mr. Pawar,
Yeah.
just a minute. We are not inclined to sustain this order. We are not inclined to sustain this order. We are setting aside the single judges.
my lord, then my
And
lord.
we are also setting aside the.
No, in
order
that
of the
case,
deputy
in that,
commissioner.
no, my lords, in that case, my lord will hear this matter because
We
though
are
the
hearing.
single judge has confined himself to that position, that fact only, but there are some other facts also. The building permission also is not is in his name. The premises where his the complex is, my lords, it is not in his name of these other petitioners. My lord will come look at page 170. It is his own admission.
Is that a
He has
condition?
replied.
Is that a condition precedent for grant or license?
My lord, the premises
He
is,
not take
my
the
lord,
Just a minute, can he not take the premises on rent?
my lords. No, my lord. the
Now,
prem-
we are not treating it in this context, we are not treating it as res commercium for different reason. Res
No.
commercium is in these matters, in matters of excise, the state can take control. But then he is a licensee for a long period and look at the complaint. That's on some anticipated, disorder in the society.
My lord will kindly come to page 170, his own reply. Page 168, it starts.
170.
170, it's the concluding part. 168 is his heading. 170, my lord will see. He has himself admitted
What has he admitted?
that 6 out of 24 has still objections.
That's all.
Secondly, my lord will see second.
Look at the content of the objection.
My lord will kindly see the other one, the second ground also. There's a, my lord, there's a park, that's that area, that shop where it is located, my lord, is a parking area. That parking lot has been
Then
converted to a
carrying
wine
on-
shop.
Then carrying on any business would be difficult in any area.
In that case, my lord,
And you know,
this
before
this
the
will dilute,
license,
my lord.
before
This-
the license is granted, all concurrence
my
was
lord,
given
if
when he
these-
when he got his place
if
shifted
this
in
order is-
2022.
If this order is, my lord, is interfered, my lord, this will dilute the whole object of the act, my lord. Because
you
we have to hear one fellow also.
You can't behave like a king that you will stop anybody from doing anything. That's not done unless it is necessary. That choice has to be of the licensing.
My lords, the rule says it will dilute everything, my lord, because this is if this kind of observation is made, my lord, it will dilute everything. The 6 people are still there within the radius of 75 meters. It's not a case that they are beyond 75.
They're not questioning that. They are the occupiers of land within 75 meters. Out of 24, 6 have objected. We are looking at the nature of objection.
My lord.
They say that because of the 2 shops, criminal activities would increase. There is an apprehension that it
That
might
I understand,
increase.
my lords. That we understand. But my lords, there are some
That is
other
the ground.
issues also I like to point out. If lordship takes it up all day after tomorrow, my lords. If lordship takes it up in day after tomorrow.
Why do you have to take it
No, my
personally?
lords, because we have
Mr.
filed,
Gogoi?
my lords, there are some grounds also. We had
What
filed
are
an
the
affidavit.
grounds? Then can you, Mohinder Singh Gill comes against you. What is the ground? The
My lord,
ground is
we have-
only the objection by 6.
My lord,
I mean,
detail-
let this
Let-
IMFL shop not detain us for
detailed
more than
affidavit
2
was
minutes.
passed. My lord, detailed affidavit was filed there, indicating everything.
Show us, Mr. Gogoi. You are appearing for the excise department.
Yes, my lord.
I'm sure the excise department has he did not grease the palm.
My lords. One.
I mean, IMFL shop relocation should not detain this division bench for more than a minute. Mr. Gogoi,
My lords.
you're consuming
my lords.
public time
No, my lords.
and you're concerned about public order.
My lords, see kindly page 124. 124, our affidavit was there.
I don't know what is your vehemence, makes us further inclined to allow this petition.
124, my lord. We have
Yes,
indicated
124.
everything, my lord.
There's nothing.
194, paragraph 12, my lord. This paragraph explains everything, my lord.
That you said.
Yes, my lord. And then my lord will kindly come to. My lord, the nature of the building where it is situated, my lord, it is also indicated in page 129.
Page?
129, my lord. Our affidavit.
Read the relevant line that you want us to see.
My lord, the premises residential, my lord. That premises the shop is located as a residential premise, my lord.
But the house owner
It's-
has,
No, my lord, that is exactly the point, my lord. That land still stands in the name of one Abhijit Roy. There's a title pursuit pending, my lord.
has he opened a petrol pump where he needs to have his land registered in his name?
No, my lord,
He has taken a place on rent.
on rent from other person who's not the title holder of that land also.
He is holding, he is arguing for the civil suit.
No, there's a proxy litigation. I'm sorry.
No, not proxy, my lords. It's true nature because during the deliberation of the matter, everything
No,
was
you should
discussed by the
accept
single
that.
judge, my lord.
That there is a dispute.
Everything was discussed,
And if there is any dispute, he will otherwise go. The premises would be locked, sealed. He will have to take away his shop, but not.
The learned single
this
judge, though he
complaint.
confined himself only to this logic, this stand, but there were other deliberations on the matter also.
Give him another notice, but this goes.
Yes,
Give
we are
him,
at liberty.
give him another notice. You cancel his license. We are not bothered. But
Yes.
today we don't find any justification of the order.
And then also lordship will kindly confine this, whatever order lordship is passing only to these facts, because it may dilute some other cases also.
Do we need to say that?
Yes, my lords, because people
Do we
come,
need to say that?
no, my lords, still
This is
then,
with respect to a litigation which has been brought before this court. Now, we are not giving Mr. Kumar any permanent, relaxation for all times to come. You cancel his license, We don't know. But then rule of law must exist.
Okay.
You can't behave like a king of the area. And 5 of the residents, 6 of the residents cannot stop this unless they have a genuine complaint.
I'm very sorry, my lord, but this may dilute, my lord, the provisions, my lord.
This
these
will
are very
dilute the provision.
Yes, my lord.
Anyway, you challenge this order. If you find that this order would dilute the provisions, says it has the
Because
potency
it
of diluting
doesn't say,
the
my lord-
provision, you challenge the order.
It doesn't say, my lord, that
This is
one
not
cannot
rest
be heard, my lord.
No, sorry. Sorry, let's not stop here now. We have heard Sri Kumar, learned senior advocate for the appellant, and Mr. Gogoi for the respondent / excise department. The appellant has questioned the judgment dated 1/11/2025 passed by a learned single judge of this court in WPC 1653 of 2023, whereby the decision of the Deputy Commissioner Kamru directing the appellant to shift his liquor shop to any other location that conforms to all the norms regarding location of a liquor shop. Or else appropriate steps would be taken for closure of the shop in terms of Assam Excise Act 2000, read with Assam Excise Rules 2016. Has been sustained. The case of the appellant is that he had been running a licensed IMFL off retail liquor shop under license number 52/2000-2001 since the year 2001. The license had been regularly renewed every year, including for the current financial year 2025 to 2026. In the year 2022, he had shifted the shop to a new premises at house number 22, Banful Path, Hattigaon, after obtaining all required statutory approvals, namely NOC from Guwahati Municipal Corporation, neighborhood consent, majority of the residents had no objection, and the final sanction from the Commissioner of Excise. The appellant had been running his shop peacefully, but sometimes in February 2023, 6 local residents out of 24 residing within 75 meters of the IMFL shop of the appellant filed objections. So the objections were in the nature of supposed disorderly behavior of the society with the existence of 2 liquor shops in an area. There was no complaint of any nuisance or law and order problem or any violation of excise norms by the appellant. Nonetheless, based on the aforenoted complaint of 6 of the residents, the District Commissioner Excise, Kamrup M, issued a show cause notice to the petitioner, to the appellant to which he had applied, and on 23/2/2023, passed an order directing the appellant to immediately shift the shop to some other location. The learned counsel for the appellant, Mr. Kumar, learned senior advocate for the appellant, has submitted that the Deputy Commissioner Excise, District Commissioner Excise, Kamrup, did not consider a major aspect that majority of the residents did not have any objection, and that the objections raised by 6 of the residents was only in the nature of an apprehension in their minds that something in future could happen which would disturb the law and order situation, or could disturb the peaceful, or could hamper the peaceful existence of the residents. If this were the genuine complaint, the complaint would have been directed to would have been directed against the other liquor shop as well, which is existing in the same locality. Rule 294 of the Assam Excise Rules 2016, which primarily deals with closure or shifting of the licensed premises. Mr. Kanwar argues, has been complied with. There is no finding while asking the appellant to relocate his shop that any public interest or necessity requires such relocation. The shop was relocated in the year 2022 after all the mandatory requirements were satisfied. The appellant also grieves that no personal hearing was attended to him. The learned single judge did not interfere primarily on the reason of 6 residents having complained against the running of the liquor shop of the appellant, and that trade in liquor is only under a license, where a licensee cannot have a vested right or a fundamental right of running his shop from a particular place. True it is that a licensee does not have a fundamental right to continue running his shop from a particular place. But once, after all sanctions having been satisfied, all clearances having been satisfied, the shop was allowed to be relocated and being run. There has to be good reasons for asking the appellant to relocate it. Without any plausible reason, any order of relocation severely hampers the right of a person to carry on his trade or vocation. There is nothing on record. We have gone through the contents of the complaints made by the residents, made by 25% of the residents about the possibility of a law and order situation if the shop is allowed to continue. We are at a loss to understand that if this apprehension was correct, why was this complaint not issued? Why was this complaint not directed against the other liquor shop? Prima facie, we find it to be a proxy litigation for some other reason. Though Mr. Gogoi, while defending the order of the District Commissioner Excise, Kamrup M, and the judgment impugned in the present appeal, submitted that there were other reasons, but he could not demonstrate those reasons except the fact that there is some dispute with respect to the ownership of the landowner from whom the appellant has taken the rent on, has taken the premises on rent for running his shop. Thus, finding the order passed by the District Commissioner Excise Kamrup M to be absolutely unjustified and no good reason in the learned single judge's order, no good reason in the impugned judgment to justify such a decision by an executive authority. We set aside the order passed by the District Commissioner dated so and so, as also the judgment impugned in the present petition. However, we make it clear that in case any complaint comes about any law and order problem because of the shop of the appellant running there, fresh action could be taken against.
Or also, well, as any deviation from the rules, by the way, found.
Or for any breach of the excise rules. Or
Obliged.
for any breach of the license or of the excise.
That's always there, madam. We are obliged.
The appeal stands alone.
I is also disposable. There is a separate.
I. I'm done. I. Item 13.
Yes,
May I please, Lordship? My lord, that's why I challenge the order of single judge, my lord.
yes,
Page number 127, start from 127, my lord.
yes.
The appellant here is dismissed from service on the ground of unsuitability, my lord. He is serving the SSB, my lord. So while, my lord, he was dismissed for the suit of unsuitability, my lord, Rule 18 of SSB rules was not followed, as well as 26 of SSB rules, my lord. My lord, so far, rules 18 of the SSB rules, my lord, commandant has no power to remove the appellant on the ground of unsuitability, my lord. Kindly peruse the, my lord, 18, my lord.
18 10 put here. 26 put here, 18 put here. You were a deserter and you're suffering from psychological diseases. You emerged from nowhere. Your family did not have any idea where were you. And then after 5 years, you you file an appeal against the order of removal. Is it removal or dismissal?
Removal, my lord.
Removal.
My lord, even though, my lord, there is a procedure prescribed, my lord, that has to be followed, my lord.
You are not to be found.
Not followed, my lord. My lord, kindly say rules 18, my lord, of SSB rules, my lord. My lord, authority, may I read, my lord? Authority is specified in the headings of column
Referring to 18.2,
18.2, my lord.
Sastra Sima Bal Act.
Unsuitability. He was terminated, removal from post of, for the offense of unsuitability, my lord. 18.2, unsuitability. Commander has power to impose punishment, my lord, under 18, my lord, dismissal, removal, discharge, retire, or release, my lord, or any other punishment specified under the act by the member of the force specified, my lord. That was
Are you
given-
reading for us or reading for yourself?
my lord.
Are you reading for us or you're reading for yourself? You refer to the act, but you're reading from the rules. Rule 18 of the Sastra Sima Bal Rules 2009.
My lord,
You're referring to that, no?
my lord.
And now read it.
Authority is specified in the heading of columns 3 to 6 of the table given below. Shall be competent to dismiss, removal, discharge, retire, or release, my lord, or any other punishment specified under this act by the member of the force specified in columns on the ground stated in the corresponding entries in column 2, my lord. In column 2, in accordance with the procedure laid down in this chapter, or any power conferred by this rule, or any provision of this chapter, or on any of the opposite authorities may also be exercised by any other authority superior to it, my lord. Let's come to the table, my lord. Under column 2, my lord, some unsuitability. He was removed for unsuitability, my lord.
And desertion.
No, unsuitability, my lord. Kindly see the removal order, my lord. Unsuitability, my lord. Then come to the procedure rules 26, my lord. For that offense, my lord, what is the punishment, my lord? Rules 26.
Yes.
Termination of service of enrolled person on the grounds of unsuitability. Where a commanding officer not below the rank of commandant is satisfied that an enrolled person is unsuitability to be retained to the force, the enrolled person shall be so informed. He must be informed, furnished with the particulars in all matter adverse to him. Call upon to urge any reason he may wish to put forward in favor of his retention in the service, provided that clause A, B, and C shall not apply if the commanding officer not below the rank of commandant is satisfied that for reason to be recorded by it in writing, it is not expedient or reasonably practicable to comply with the provisions thereof. Furthermore, provided further that such competent authority may not furnish to the enrolled person any matter adverse to him, if in his opinion it is not in the interest of the security of the state to do so. Second, my lord, after considering the explanations, if any, the commanding officer not below the rank of commandant may call upon enrolled person to retire or resign, and on his refusal to do so, the enrolled person may be compulsorily retired or discharged from service. That was a punishment, that no removal, my lord. But I was removed, my lord. Prior to that, this 26 had to follow, my lord. And no so-called notice was issued, even served, calling for explanation in terms of rules 26, my lord.
No, we are not inclined. We have heard Sri K.P. Chauhan, learned advocate for the appellant, and Mr. R.P.D. Chaudhary, learned deputy SGI for the respondent. By the judgment dated 14/10/2024, passed in WPC number 5205 of 2017, a learned single judge of this court has approved of the removal of the appellant from the service of the Constable General duty on account of his unsuitability for being continued in the service. The appellant was declared a deserter the appellant served as a constable bracket GD in Sahastra Seema Bal at Bongaigaon. He had availed of the earned leave with effect from 5/10/2009 to 13/12/2009. But he never joined his service thereafter. His contention is that he was under treatment for his mental illness during that time. The aforesaid fact has been disproved by the authorities, and the same has been accepted by the learned single judge. When the appellant was not found to have resumed his service for a period of 60 days after the completion of the period of his sanctioned earned leave, a court of inquiry was convened which reported that the appellant was a deserter from the force. This order of the court of inquiry was attempted to be communicated to the appellant at his residential address, but there was no response in connection with such decision to hold the appellant as a deserter. The respondents thereafter requested the Superintendent of Police Barpeta to apprehend the appellant, but to no avail, for the reason that even his family members had no idea about his whereabouts for the last 2 years. Thereafter, the commandant of the 15th Battalion of SSB Bongaigaon recorded the fact that the appellant had overstayed his leave and was declared a deserter. And by communication dated 13/7/2010, asked the appellant to join his duties within 15 days from the date of issuance of such letter, failing which he would be removed from the service. Since there was no response to this communication as well, the Commandant 15 Battalion SSB Bongaigaon, by his order dated 12/10/2010, removed the appellant from service by invoking the provisions of Rule 18 bracket Roman 2 of the SSB Rules 2009, read with Rule 26 thereof. The provision of Rule 18 bracket 2 empowers the commandant to impose the penalty of removal from service of an enrolled member of the force on the ground of unsuitability. The procedure for termination is provided under Rule 26, which provides that before passing such order of termination, the concerned member of the force shall be informed about his unsuitability, semicolon, would be furnished with the particulars of all matters adverse to him, semicolon, and shall be called upon to urge any reasons he may wish to put forward in favor of his retention in service. The proviso in Rule 26 further clarifies as to what steps be taken if there is no response from the employee. The major contention of the appellant here is that the provisions contained in Rule 26 of the SSB Rules 2009 was not followed before the order of removal dated 12/10/2010. The facts of the case are self-explanatory. Stop. The appellant was declared a deserter as noted above, based on the recommendations of the Court of Inquiry. Thereafter, attempt was taken to apprehend him, but to no avail. Thereafter, the Commandant 15 Battalion proceeded to remove the appellant from service, for which a necessary communication was made, which also went unresponded. The appellant never resumed his service nor submitted his response to the communication dated 13/7/2010.
My lord,
13/10/2010. The appellant could not be informed because he was not to be found. Even his family members, as noted above, had no idea where had the appellant disappeared. If he was having any medical problem, he could have informed, he or his family members could have informed the unit. But complete absence of any communication from the side of the appellant made it very clear that he was a deserter from the police force, making him absolutely unsuitable for being retained in service. Stop that apart. When, after 5 years, he appealed against such order, along with medical prescriptions of his illness, the same was also not found convincing, and the appeal was dismissed. The learned single judge examined the medical papers furnished by the appellant and found that the treating doctor had certified that the appellant had been suffering from psychological illness of long duration, which had severely affected, which had severe debilitating impact on the cognitive faculties of the appellant, including his mental tranquility. Even during the period when he was treated, even during the period that he was under medical treatment, he had absquatulated. However, the treatment was restarted, to which the appellant had responded. He was but advised for not taking alcohol during the treatment period. Stop. There was another certificate on record indicating that the appellant had improved significantly and had responded well to the medication. The learned single judge did not find this to be a reason for complete non-communication, for non-communication from the side of the appellant. This is desertion simplicity. The order of removal, in our estimation, was justified. We therefore put our imprimatur to the judgment which has been questioned in the present appeal and dismiss this appeal in limine.
My lord, one more thing, my lord.
Shall next?
My lord,
Yes.
one more thing, my lord, kindly.
You are not suitable. Forget about rules. Absolute unsuitability. We have all sympathies for you, but then you are not interested in your service.
My lord, only one things, my lord. My lord, 13/7/2010, my lord, notice what, my lord? Kindly page number 73, my lord. Addressee out of station, return to the center, that may be recorded, my lord.
Not necessary. What we have recorded is all necessary facts on which this judgment ends.
Item 14.
Let us hear it. Yes, Mr. Chair.
My lord, a tender was issued by the NF Railway for construction of second rail cum road bridge over River Brahmaputra at Saraighat. In fact, this would be the third bridge.
Consider, आपको reject मत करो. Consider.
Yes.
So NF Railways issued a tender for road cum rail bridge construction.
Yes,
You participated in that tender.
I participated.
Yes.
With a caveat, my lord. There was a particular clause, debarring clause. That is 2.2.2.4.322.
2.2.2.4.
Yes, that is at my lord,
In the
page
RFP.
number,
In the RFP.
in the RFP, page number 84, my lord. Please come to page 84, last three sentence, my lord. 2.
84. Yes.
There should not be history of collapse of superstructure, substructure of any span of a bridge, flyover, viaduct, metro rail line during construction, service in the last 3 years ending last day of the month previous to the one in which tender is invited. Undertaking in this regard shall be submitted along with the bid. My lord, we submitted an undertaking. Now,
You
what has
submitted
happened,
an
my lord?
RFP. Yes. But
Now,
why
kindly-
why did you question this?
Yes, we question this because, my lord, this is a very vague, my lord, clause.
Why?
But there could be a case
Hmm.
where the collapse could be on account of design failure. The collapse could be on account of, my lord, faulty construction. Now, if it is a case of design failure, then it cannot be attributed to the, builder, my lord. If it's a case of faulty construction or something like, or using, my lord, the substandard material, etc., then it can be apportioned in against the, my lord, builder. Now, it is open-ended, nobody knows, my lord. Now, what had happened, my lord? The petitioner had was a contractor for construction of a bridge over river Ganga in Bihar, state of Bihar, Milord.
Which collapsed.
There was a collapse. Now it led to a public interest litigation, Milord. Now kindly see the order in that
I'm
case.
aware of it.
Yes.
I'm
So,
aware of it.
Milord,
And the
in
same-
fact,
Just a minute. And the same contractor
yes,
had undertaken, he was given the contract for building, for constructing the new building of the High Court,
yes.
which he abandoned, ran away
Acha,
because of the FIR.
acha, acha.
Right.
Anyway, Milord,
So that had to be given to another,
No.
another.
presently, Milord, presently this present.
If he's the same person.
Maybe. Milord, the present contractor presently, Milord, he has already constructed one bridge over river Brahmaputra in Kolia Bhamura. My Lord Justice Arun Dev Chaudhary will know, Milord. The second bridge he has constructed. Now he is constructing a bridge, Milord, in Milord Panchatantra in Bongaigaon. This second bridge, there he has completed 60%. And the bridge which is.
That's all right. That's all right.
No, and the bridge which is presently,
So
Milord.
you have to your credit one collapse and two constructed bridges.
No,
We have
several,
followed-
several.
Several. We have
Yes,
followed that.
yes.
But question is this,
Yeah.
now you question this condition to be vague,
Vague.
but still you replied that yes, there is no collapse. And this
No, we
condition,
didn't say there is no collapse. We said there is a collapse, but with a caveat, we said
Hmm.
under these circumstances, it collapsed.
Hmm.
Therefore, and my lord, the contractor, sorry, the state government of Bihar or National Highway Authority, hota? But no, state government of Bihar has permitted me to construct. It's an ongoing project. I'm undertaking the construction.
then he is not the same person about whom I'm.
No, the same person.
No, then my information is about something else. That
Oh,
was
ha,
different.
ha, ha.
He was hiding. He was.
Although
facing a
there is a
criminal-
separate.
He was.
I
he
don't
was-
think,
he
I
was
don't
facing
think
a
Patna High Court construction was given to
was-
us.
No.
Yes,
Okay.
yes.
The
Yes.
person concerned in
Ah.
that case
So-
was one bridge in Calcutta had collapsed.
Okay.
So he had gone in hiding.
In fact, my
He's not
lord,
the same
in
person.
fact, the person whom they have chosen now, but for him, my lord, the clause has to be brought down to 3 years. They have admitted in their affidavit.
No, just
Earlier it was 5 years.
one second,
Yes.
sir. We are at a different.
Yes.
Uh,
Now, my lord, my
No,
submission is,
eligibility, just a minute. This comes under 2.2, eligibility and qualification requirements of a bidder.
it is, my lord, 2.2.2.4, Roman 3 within bracket, Roman 2 within bracket, and numerical 2.
Categories and factors for, this is for evaluation.
Yes. Categories and factors for evaluation of technical capacity.
Page 81. Qualification requirements of bidder. To be eligible for qualification, an individual bidder or consortium as a whole shall fulfill the following conditions: of technical capacity is all right. Then financial capacity. So financial capacity for the purposes of this construction. Bidder should demonstrate at least one experience as 2.2.1 in last 5 that clear below. Bidder must have completed one bridge in railway sector in what is done. These two requirements can be demonstrated as an incomplete project qualified. There should not be history of collapse of superstructure, substructure, fakes, all right, okay.
So
this
now
certification
Lordship has noticed, my lord, therefore this clause even does not exempt reasons on account of force majeure also. So therefore, my lord, Supreme Court has said
So
such
that
clause
would
cannot be operated,
That would be subject to evaluation.
subject to evaluation.
But you have to state this fact.
Yes, but where is that notice? That's why Supreme Court, I have brought 3 judgments of the Supreme Court, my lord, where it says you can't apply such clauses. You can't apply such clauses to debar somebody. 3 judgments of the Supreme Court.
Which are those?
Yes, they give the compilation. Well, 2 compilations you have already given, my lord. If your lordship would kindly come to the compilation, my lord. The compilation would have been, no?
Yes.
Yes, please come to page number 56, my lord. That is Blue Dreams versus KMC. That is INSC 589. It starts at page 56. And lordships will kindly come to page number 75.
75.
Yes, para 26 and 27. As Supreme Court says, Millet, it's a case of civil death. In other words, where the case is of an ordinary breach of contract, an explanation offered by the concerned.
But Mr. Chaudhary, this is with respect to debarment.
Yes, well, indirectly, this is debarment. The
No, no.
moment you take note of this, you are debarring.
No, no.
Supreme Court says, I'll place to two other judgments. Millet.
And Blue Dreams, therefore, I was confused why you are bringing Blue Dreams.
Yeah, it's
Blue
a case
Dreams,
of
I remember
debarment.
it is
There-
Justice
there-
Vishwanathan, he has dealt with,
Yes.
there
There-
should not be too readily, a decision to debar.
Yes, please come to then, Milord, the UMC Technologies case
Ah.
at page 108, relevant is at 120.
I'll be telling you that.
Para 25,
Para 25.
yes.
Hmm.
The mere existence of a clause in the bid document which mentions blacklisting as a bar against eligibility cannot satisfy the mandatory requirement of a clear mention of the proposed action in the show cause notice. The corporation's notice is completely silent about blacklisting, and as such, it could not have led the appellant to infer that such an action could be taken by corporation in pursuance to this notice. Had the corporation expressed its mind in the show cause notice to blacklist the appellant,
So this is.
appellant could have filed a suitable reply for the same.
No, 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 sir,
In this
these-
case, there was a
these are-
notice,
these
but the
are-
notice was silent.
No, no.
Even then, Supreme Court said,
That's you would get better judgment.
yes, my lord.
No, no,
My lord,
these are,
we have
these are,
got a
these are
better,
not, these are not the correct judgments.
no, my lord, there is
See,
a,
the law.
there
with
is a-
respect-
there is a very good judgment of the division bench of the Delhi High Court, my lord. It was authored by Justice Ravindra Bhatt, that is at page 85, page 92. This is straightway on the point.
<clears throat> 92.
Yes, para 25. As a result of the discussions above, it is held that clause 2.1.19 of the tender condition is arbitrary and unreasonable to the extent in the matter of a case falling under the said clause, it amounts to automatic debarring of the party from participating in any other tender bid taken out by NHCI
We'll have
for a
to-
period.
Your junior will have to do some little homework.
Yes,
With respect to condition in a tender,
yes.
which is vague, which
Ah.
is difficult to satisfy,
Ah.
there are other grounds. But the law overwhelmingly in all decisions is that it is the employer, the person who floats the tender, he knows best what
Yeah.
does he want.
Yeah.
Now, with any person having constructed a bridge or a span of bridge or anything which has collapsed, they would, the authority would like to steer clear, whether it is for force majeure or whatever. You can argue that. So this is subject to evaluation.
Yeah.
Therefore, question is this, question would be twofold, that you considered it to be vague for the purposes of evaluation. So, but you gave your certification that these are because you needed two out of it within the period. So you have two experience. So you have given that certificate. But you have also very fairly stated that one of the bridges collapsed
Hmm.
for this reason.
Hmm.
So this was subject to evaluation. Now, we are steering clear of the interim order and the violation of the interim order concept for the moment, because we'll be deciding this petition in its entirety, if you so like. Otherwise, it is the option of the petitioner. Because this appeal is against an interim order.
Interim order.
So, but if you want, we can hear the entire matter, because that we are not considering. Interim order appeal, it is not necessary here. Now, overwhelmingly, the order is that the conditions of the tender, unless it is absolutely perverse, it cannot be questioned. The second law is that if you participate in it, then perhaps you can't question it. In your favor, there is a judgment, but that is in service law. It is about a doctor who had applied in a university in Bihar. I don't know, Dr. Malti. That is the only case where the judgment is rendered by Justice Suryakant, which says that without entering into the fray, the vulnerabilities will not be noticed. But that is again in a different concept. So far as this is concerned, Jagdish Mandal holds the field that all these minor aspects, you please, I mean, keep it at bay. Now, question is that you have participated.
Then, my lord,
Then next. Has your bid been rejected on this count?
yes,
Where is that?
yes,
Where is that?
yes, my lord. Page number. आगे हुए 1 second, please. To copy of the 222 my lord, screenshot.
Page
222.
Page
222.
222.
In fact, on two ground, the other grounds I will satisfy, my lord.
Yes.
2.2.2.4322. My lord, we have given them qualified undertaking. They could have posed us the question, we could have explained. That is the purport, my lord.
Rejected, non-responsive as per 2.2.2.
Ah,
Is the same
that is
thing.
different, that is different. I
What
will come to that.
and clause 2.2.4322.
This is the one.
So this one. So how about this?
Yes.
2.2.2.2.
Now, what about this is, my lord, that your lordship will get at page number 83. In the middle, the bidder shall have a minimum net worth, financial capacity of amount equal to 5 of the estimated project cost at the close of the preceding financial year. It comes to about 75 point some crore, my lord. Now, what had happened, my lord? We submitted the bid on 22/8/2025. On that date, my lord, the balance sheet and financial statement for the year 24/25 was not ready. So what we did, my lord, we submitted for the last 5 years. And in any case, my lord, for 24/25 against the requirement of 75, we have 1,333 crore. But there is another clause, my lord, 27. Kindly come to page 86. 2227 Roman 2. Towards the bottom of the page.
Yes.
In case the annual accounts of the latest financial year are not audited and therefore bidder cannot make it available, the bidder shall give an undertaking to this effect and statutory auditor will certify the same. In such a case, bidder shall provide audited annual report for 5 years preceding the year for which audit report is not. We have provided.
But why have they rejected it?
Lord,
Why have they rejected it?
because of this certificate, my lord. Please come to that one.
No, but there must be something in the clause. which
No,
says-
yes. My
There-
lord,
just a
page
minute.
number 210.
We would like to know from you.
Yes.
There must be something in this RFP
Huh.
or in the tender paper
Yes.
providing for a window to you
Ah.
to explain.
Yes,
So that you explained.
yes.
You explained. Did you explain?
My lord, our undertaking was there. Undertaking explains everything.
No. After the decision,
Oh, no, they have not posed us any question. They straightway rejected
post
it.
the decision.
No,
Post
even-
the decision, they ask for an explanation.
No, they have not done it. They have even before or after. My lord, will kindly come to 209. Yes. Because this was for the year, my lord, 23/24. In any case, my lord, my audit report is to be submitted by 30th September as per the Income Tax Act and the rules. So where is the question? Page 209. Kindly see, my lord, it was 1,124 crore as against the requirement of 75 crore. It was submitted on 22/8/25 and it was for the year 23/24. And in their affidavit, they have disclosed. And my lord, that undertaking and the 5 years annual statements were submitted. My lord, and the person whom they had given now made him responsive as L1. My lord, his BZ is much higher, my lord. I have not disclosed my rate, but my rate is much below, substantially below.
That is no concern.
No, another question is, my lord, when for this you could not have done it because 2.2.2.7.2 we have followed.
We will hear you. But interim, it's
No,
difficult.
my lord, my only prayer is, my lord, they have issued an LOA. Let them not enter into the contract, my lord. It's a huge contract, maybe it will take 5, 6 years. Another 1 month whole matter
That,
can be
Mr.
decided.
Mr. Chaudhary, that would be difficult. Project of this kind, public
Subject to the
project, we
outcome.
don't. You can,
Subject to the outcome.
subject to the outcome you already
Yes.
have. You
Lord.
already have.
No, my lord,
Subject to the
but in the writ appeal, my lord,
Subject to the outcome you already have. You
No,
already-
the only thing is, my lord,
You have that order.
yes,
Show-
my lord,
show-
it's not a very heavy matter, my lord. It's a very simple matter, my lord. It can be disposed of, they have filed their affidavit. But we can hear it and dispose of,
No,
my lord.
but the person who has been, who
No,
has
no,
been
we are
appointed-
filing the second writ petition, already you have filed it, you have mentioned it for Friday.
You have mentioned.
Yes, today we have filed it, my lord.
So we will hear it on Friday or next Friday,
Okay.
next Friday.
Till-
You remind us on the Friday.
Friday, next Friday.
No. So therefore, that goes before the single judge.
हाँ.
हाँ, ठीक है, उसको बहस करवाइए, you
हाँ.
argue that. And you tell us, we adjourn this matter for the next day.
Or lordships can hear the whole matter, we don't have any objection.
Let it be.
If the other side have no objection, lordship can hear it.
The other side would lose a forum, no? You know, in Bihar, what we did was that all contract matters, all tenders, first instance, it came before division bench, so that there is no time lag. It was questioned in Supreme Court that how has this been done? One forum has been lost. Parties will have to go to Delhi straight away. But then it was sustained. We decided it during our times that, all these public projects that should not be delayed. So division bench and then Supreme Court. But here Mr. Gogoi might clamor that you're losing. He would have more
No, my
confidence.
lord, yes,
You would have-
normally it's a
Mr.
very
Chaudhary, I'm
important
saying that-
project. But
I'm-
then, my lord, kindly see the extent of
Mr. Chaudhary,
arbitration.
I'm saying something else. Now, I'm saying something else in a different, vein. Mr. Gogoi may have more confidence on single judge.
Only thing is, my lord, let them not enter into the agreement.
So far as this appeal is concerned,
Yes.
we are not finding fault with the order passed by the learned single judge when he did not take notice of the fact that consider his application. Consideration of his application means don't non-suit him without considering for absence of any certification.
No, my lord.
So therefore, consider his case. That was the
There,
interim
there,
order.
there I have a submission, my lord, for a lordship's kind concern. I think we are complaining that this is a clause which is coming in our way. Not, despite that, when a judge says, my
Then
lord,
you should not have asked for consideration. You should have objected to it.
no, my lord,
You should have said that this clause is bad. This clause automatically shuts me out.
notwithstanding that, the learned single judge said,
No,
you
no. So
consider,
therefore-
meaning
there-
thereby, you
therefore-
cannot non-suit him on this ground. That's the underlying idea, my lord. But subject to the outcome of the case.
That is sub silentio.
My lord, my learned friend has relied upon a judgment. What is the meaning of consider? My lord, when a matter is finally remanded, the consideration doesn't mean favorable consideration. That we all know. But at an interim stage, when a court passes an,
The question is, we are on a different issue altogether, Mr. Chaudhary.
no, I was only trying to explain the
Because
purport of the
you
interim order.
participated, you should have objected to even this interim order by Justice Kadar. You should have said that no consideration, we are questioning this. You are definitely going to non-suit me. Once you have participated, could
No, my
you,
lord, participation
hear
was with a caveat
all right, we'll hear you. You have passed that, let this.
on next Friday, my lord.
On next Friday,
Yes.
next Friday, yeah, next Friday.
Yes.
Yes, next Friday. we'll do.
ठीक है, ठीक है.
28,
And
28, 11.
And if they enter into the agreement in the meantime, that will be subject to the outcome of the case.
This order you have.
No, lordship will make an observation
No, no.
here also, my lord.
And, I mean, superimposition of an order of stays is not necessary.
My lord, there is a joke in Bengali.
Uh.
The joke is pillar, P-I-L-L-A-R. There are two L, my lord. The teacher was explaining in a class. A student asked, how to spell pillar? Then the teacher explained, if you give one also it will do, but if you give two, then it becomes more strong.
All right. We have heard Mr. Chaudhary, senior advocate for the appellant, and Mr. Gogoi for the respondent. let this matter come for further consideration on Friday.
28/11.
Okay.
On Friday, when is your single judge matter being
Day
listed?
after tomorrow, my lord.
Uh,
This Friday.
this-
Today we have mentioned permission has been given for Friday.
Don't make any reference to this bench. You argue your merits there.
Lordship.
31 to one.
Anyway, yes.
And my lord, one more thing, my lord, this order, subsequent order, that will not come in the way of the learned single judge in deciding the second petition.
No, it shall not. It's a
Well-
fresh action. This is pending, Not at all. Not at all, Mr. Chaudhary, you know the skills.
Deeply obliged.
Item number 15.
Yes.
May I please?
Mr. Counsel, we could have, this is an innocuous petition where we can direct the district magistrate to pass an order, to observe his obligation. Correct?
Yes, ma'am.
That's all you want.
Yes,
But then we have to issue notice. The difficulty is this, that these days, such kind of orders are passed which are to the disadvantage of the private party, of the borrower. Many a times, because he would have appeared he would have moved DRT under 17 or whatever, we don't know. So on the first day, I used to pass orders. In fact, we have been passing orders. But in one case, it so happened that that is the difficulty. So we'll issue notice. Otherwise, you have a case under section 14, the DC has an obligation to facilitate you. He has not been doing it.
We have filed petition there.
Followed it. Don't you understand what the court is saying? Innocuous means there is no difficulty in disposing it of today. But let us hear from MS Bora. You find out why district DC is not doing it. We also issue notice to the private party. Are you interested?
Let's say.
Are you interested?
No, ma'am, it will delay.
Take them. The petitioner / State Bank of India, through its Vishwanath Chariali branch, seeks a direction to the district magistrate, Vishwanath, for passing necessary orders under section 14 of the SARFAESI Act 2002. And to expeditiously dispose of the application filed by the petitioner for facilitating the taking over of physical possession of 3 mortgaged immovable properties of the defaulting borrowers. The scheme of SARFAESI Act makes it very clear that on an application filed by a creditor, secured creditor, the DC will facilitate the taking over of the physical possession of the mortgaged property. MS Bora, learned government advocate Assam, to inform this court as to why no action has been taken despite 4 months having been elapsed since the filing of such application by the petitioner, the State Bank of India. Re-notify on Wednesday. And then we'll issue notice to the other.
Yes, ma'am.
Problem. January. There are 2 orders of the Supreme Court, Mr. Counsel, for your consumption. They say that don't issue a mandamus to a DC. Just remind him that this is his responsibility. We had been issuing orders straight away.
19 January. Item 16.
Lens to the rules of 2005.
May I please, Your Honor?
16 law say I pray for accommodation. We have to file affidavit in this case law.
Yes, the rules are under.
Rules are 7.
A, B, 2C, and 3 of Assam College Employees
Lordship, Lord.
Provincialization Act 2005.
So.
Ah.
No, Lordship,
January.
Lordship law.
Okay. By the present petition, comma, the petitioner seeks a declaration that sections 2 bracket A, 2 bracket B, 2 bracket C, and 3 of the Assam College Employees Provincialization Act 2005 is unconstitutional and ultra virus to the extent that these sections exclude pre-provincialization / pre-grant in aid service from being counted as qualifying service for pension. Mr. Gogoi, learned government, your government advocate. Learned government advocate. Your government advocate.
Standing Council Higher Education.
Mr. Gogoi, learned Standing Council, Higher Education, seeks some time to respond to this petition. January.
28th January.
January बोलता है तो February भी करना था.
Item 17.
Malad, kindly peruse the last order.
गद्दा लगवाते हैं. Yes.
Well, kindly peruse the last order dated 28/4/2025. This honorable court was pleased to direct the
28/4/2025.
25.
Mr. Nath, Senior Government Advocate, please pronounce the 3 weeks time to the state respondents formulate procedure for appointing a license. Yes, what have you done, Mr. Nath?
Malad, it is under process, Malad. I have not received the final instruction, Malad. Some time is required. The procedure is not there, but it is under process.
But it is in process.
It is under process.
Take that. By order dated 24/2/2025, a coordinate bench expressed surprise as to the absence of any prescribed procedure for appointing a licensee to run a fair price shop. Mr. D. Nath, learned Senior Government Advocate, submitted before the bench that the state would formulate a procedure for appointing a licensee to run a fair price shop under the Assam Public Distribution Particle Order 1982. Today, Mr. Nath submits that the formulation of the procedure is underway, and by the next date, he shall be in a position to inform this court whether the policy has been formulated. Let this matter come up for consideration on. Give a date in early Feb.
Malad, the interim order passed earlier may continue.
Interim order, then we will decide it immediately in the absence
Yes.
of any. Huh?
Interim order is there.
Interim order, we really don't. The interim order is the shop being run. Then January. Interim order in the meanwhile to continue.
8th January. Item number 18.
Lord, the issue pertains to promotion. I just like to briefly highlight one factual premise, my lord. Is that in Assam Rifles, my lord, there are two kinds of posting. One is when you are posted in a battalion, and the other is when you are posted in a headquarters or a DIG unit, or there are some special units like a dog squad. And in this particular case, he was placed in a Assam Rifles Field Intelligence Unit. That is one aspect of the matter. And then, my lord, as far as promotion is concerned, there is nothing as such in the recruitment rules, but then there is an executive instruction which says that you have to, out of last 5 years ACR, 2 has to be at least from the battalion. So only those will be counted for the purpose of promotion. In this particular case, my lord, this particular petitioner, he was posted in a ERE field intelligence unit in 2015 for an initial period of 3 years, which is the normal tenure. So had he completed his tenure and come back to the unit in time, he would have still had a chance to earn 2 ACRs from the battalion. But then he was not given a reliever, and consequently, he had to stay in the ERE duty for 4 years. And then when in 2020 his promotion had come up, his promotion was rejected by saying that you had not earned 2 ACRs from the battalion, and therefore, my lord, his promotion was turned down. My lord, the learned single judge had, however, my lord, considered the matter in a different perspective.
He said that it was at your request.
My lord,
So your request was acceded to
my lord,
for a non-field posting, and therefore you must bear the brunt. That's what the single judge said.
my lord.
But while parting, he says that it is not correct. The rules must undergo a change.
My lord. In fact, Meghalaya High Court had already, my lord, interfered. I had already enclosed that particular judgment. And
You enclose that judgment?
Yes, my lord. But you would see. Annexure 4, page 71. And page 76, para 13, my lord, is the effective part.
Page?
Page 76, para 13 is the operative portion, my lord. The court says that DRE duty is also part of the same organization. It cannot be therefore treated as
Para-
something foreign.
Which paragraph are you referring?
Para 13, my lord.
You read the paragraph.
This court is not persuaded to approve of the action of the respondents as to why, when the petitioners were sent on extra regimental employment, ERE, to duty to headquarters IGR North, Nagaland, Kohima as intelligence ratio in public interest on 10/4/2010, within the same organization, the ACR grading earned by him should not be considered for promotion. Legitimate right of the petitioner for consideration of promotion cannot be certified by involving such arbitrary executive instruction, and his junior could not have be preferred over him owing to such fortuitous circumstances, which is not under his control. Since the respondents have not disputed the assertion of the petitioner that he had earned ACR grading of very good outstanding during 2010, 11, 12, and 13, the action of the respondents in not granting promotion is declared to be illegal, arbitrary, and discretionary, being violated of Article 14 and 16 of the Constitution of India.
Recruitment and promotion instruction. It is a guideline. Yes, Mr. Chakravarti.
Lordship, just one.
We are inclined to go by the Meghalaya judgment reasoning.
Lordship,
Para 13, what do you have to say?
Lordship, that posting was in public interest. That has been reflected in paragraph 9, Lordship.
And here also it is
No.
not on his request.
No.
He has been sent. That's factually incorrect, he says.
My lord,
No.
because the affidavit, my lord, filed by them now reveals.
Then, did he make a request to come back?
No,
not?
he never filed any, he enjoyed for more than 4 years, Lordship.
Enjoy it.
Soft
Enjoy.
posting. Shillong is a soft
He's working.
posting.
I mean,
When is unique,
you people, the employer only makes a distinction between a field and a non-field posting.
Lordship,
Non-field posting is hardly enjoyable.
Lordship, when we were sent back, he was made known, Lordship.
No, how do you counter this, that he says that he was not sent on his choice?
That is, has not filed any rejoinder before the single judge, Lordship, countering the same.
No.
Because that was reflected in the rejection order, Lordship, at page.
No, you tell us. You tell us. I don't think so.
Page 37, Lordship. And it has not been challenged, neither this,
So where is that order of posting?
Lordship,
Where is the order of posting?
Lordship.
That posting order, my lord, was
Page-
not brought before the single judge also.
Movement order is at page 87.
In the affidavit now filed in the appeal, my lord, and this has come on the top.
Page 87.
Page
Yes,
87.
filed an affidavit.
It was made very clear at point number 1, Lordship.
that this is an extra regimental duty and he was known to be made known to him.
Where is it?
Point number 1, Lordship, at the top.
The rank name Rajesh Kumar Gurung will proceed to a Shillong duty as a reliever.
For ERE duty, that is extra regimental engagement.
No, but where is this is all right. That is understandable. He goes there as extra regimental duty,
Lordship.
but then it was on his own request.
Page 37, page 37.
Even if it was on his request, is that a ground? Yes.
Point number 3, Lordship.
On your request.
Lordship, on request. This has not been denied. Neither this communication has been put to challenge. While he rejected his prayer, Lordship. Kindly see the prayer in the writ petition, Lordship.
But when he must have made a request for return,
It's
where is
verbal.
that request?
We say verbal request, Lordship.
There is nothing on record. Mr. Pathak,
My lord.
where is, which part of the brief do we find that you made a request for coming back, but it was not being heeded to, and there was no reliever, and therefore you have to stay there for 4 years or 5 years?
My lord, para 8, my lord, of page 22.
No, that's your statement, but where
It's a
is the
statement, my
document?
lord. It's a statement.
Para?
Para 8, my lord, page 22. Unless a reliever is sent, I cannot of my.
No, where did you make a request? Reliever is not sent.
Para 8, my lord.
Page 32, my dear. Page 32, political. Page 32.
Page 22, my lord. Para 8 and 9 of the writ petition.
These are all oral submissions.
My lord.
So forget about this. Now, have you questioned this? The very rules? The guidelines? Mr. Pathak,
My lord.
there is no rejoinder, there is no rebuttal.
In the writ petition, my lord, there was no rebuttal. Because my lord, these people are posted outside, they cannot immediately come. So it was placed, my lord, otherwise. Therefore, before the division,
No,
my
but you
lord,
must
we
be having-
asked that the record be
must be having
produced.
Some copy of the letters which you shoot to your employer.
My lord.
You must be having some copies of the letters. Bring it before us.
There might be, my lord. There might be, my lord.
Or might be there because you have, see, there are two aspects of the matter. We are inclined to go the Meghalaya way,
My lord.
provided we are thoroughly satisfied that it was not at your request. You never wanted to come,
My lord.
and then you want your promotion to be considered without a field unit ACR.
My lord.
Now, there are two things. There is no challenge to the ROI of 2002,
My lord.
correct? If you challenge that, only then we can say that, well, this is,
We did not challenge it because, my lord, in 2019, that has already been diluted, my lord, by the Meghalaya High Court, and these orders are implemented in Meghalaya High Court. My case is of 2020. 2019, Meghalaya High Court had already diluted that ROI.
but this was, that have they said that this is bad? Has the Meghalaya High Court judgment, I mean, does that
They
judgment
say that this kind of
is
a,
bad?
they say that this kind of a condition is violative of Article 14 and 16.
That
Para
should be-
13, my lord.
That should be struck down or read down.
My lord.
That should have been struck down or read down. And there is no challenge on your part.
my lord. We,
Plus you have no document, you have not you have not controverted the statements made.
my lord.
File your
That
additional
rebuttal, my
affidavit-
lord, affidavit could not
File
be,
your additional affidavit along with the documents.
my lord.
Take note. The appellant herein is a senior warrant officer of Assam Rifles who alleges that he was wrongly denied promotion to the rank of Naib Subedar, general duty within brackets, for he did not have a minimum of 2 annual confidential reports earned from a field battalion or specified units bracket battalion / Assam Rifles Training Center and school / NSG. The appellant has 4 ACRs from the Assam Rifles Field Intelligence Unit, where he was posted on extra regimental employment duty bracket ERE from November 2015 to December 2019. The contention of the appellant is that he was initially sent on ERE for 3 years in public interest by his parent unit, that is 31st Assam Rifles. After completing 3 years, he desired to return to his parent department, but that could not happen because the parent unit never sent a reliever. The appellant, in the absence of his reliever, could not have left the Assam Rifles Field Intelligence Unit without formal release orders. His reliever came only in late 2019, whereafter he rejoined his parent unit after more than 4 years. By that time, his last 5 years ACRs were from the Field Intelligence Unit, which was not counted by the Departmental Promotion Committee for promotion. The recruitment and promotion instructions bracket ROI 4 of 2002 as amended in 2013 specifies that for promotion, an officer in 5 years must have at least 2 ACRs from a field battalion or specified units. Before the learned single judge, the appellant contended, firstly, that the ROI 4 of 2002 as amended in 2013 are only instructions which have no statutory force. And on that basis alone, the promotion of the appellant could not have been denied. The other ground raised on his behalf was that he, as a member of the discipline force, has no control over his posting or its prolongation under any circumstance. Additionally, it was argued that his ACR gradings were above average throughout. The sum and substance of his contention, which was rejected by the learned single judge, was that his posting in the field unit on ERE was within the same force and in public interest. And therefore, promotion to the higher post should not have been denied to him merely on the ground that he did not have minimum of 2 ACRs from a field battalion or any specified unit. He had also submitted, it was also urged on behalf of the appellant that Meghalaya High Court has in a large measure read down the applicability or the enforceability of the ROI 4 of 2012 bracket amended in 2013. Mr. Chakravarti Leonard Leonard CGC, however, submits that the ERE posting of the appellant was on his choice and request and not in public interest. There is nothing on record to indicate that he wanted to come back to his unit, but that was not possible because no reliever was sent. That apart, the appellant never controverted such statement of the respondent that the posting on ERE was at the choice of the appellant. The learned single judge, though did not interfere with the rules and the refusal of promotion to the appellant on the ground that the ERE posting was because of the choice of the appellant, but while parting, observed that the practice followed in Assam Rifles of entertaining verbal requests for transfer and posting makes the process questionable demanding a set of directives from the authorities so that the process is not left open-ended and process is not left open-ended, and it is easier to follow the recruitment and promotion instructions of 4 of 2002. Mr. Pathak contends that the learned single judge, in a way, found the impracticality of the ROI to stop. In that case, the decision of the Meghalaya High Court ought to have weighed with the learned single judge in deciding the claim of the appellant. Mr. Pathak further submits that he shall bring on record documents by way of additional affidavit to indicate that his transfer on ERE, his posting on ERE was not on his request, but in public interest, and that he had made requests to come back to his parent unit, but only because of no reliever being sent by the parent unit, he had to stay back on ERE posting, which in fact has damaged his damaged his promotional prospects. Let this matter come up. Come on January.
Okay.
Second February. 2nd of February.
Yes.
Item 19.
Some time may be allowed for filing an application reply.
Mr. A. Das Gupta, learned senior advocate for the petitioner, seek some time to file a rejoinder petition. Let this matter come up for consideration in February.
But sometime maybe towards me also, my lord, for filing.
In the meantime, the respondents could file,
Private.
respondents could file any affidavit if so deemed. File it.
4th of February. Item 21.
Item number?
May please, your lordship.
Yes. Yes.
My lord, in this matter, there has been a notice inviting tender been issued by the Food Corporation of India. And upon the issuance of the NIT, the petitioners have participated in the tender, subsequently have submitted an EMD amount. EMD amount was approved by the Food Corporation of India. However, and subsequently, my lord, an acceptance offer, that is the letter of acceptance, has been issued.
That's fine. Come to the point straight away.
Yes, my lord. So, my lord, after issuance of the acceptance offer, we were intimated verbally that your EMD amount will be forfeited and your acceptance offer will be removed.
Why?
Because I do not have GST registration based out of the state of Assam.
And where is that requirement?
My lord, this.
Where is that requirement under NIT that any applicant, any participant not having a GST registration of Assam shall have his EMD forfeited? There's nothing.
As per me, my lord, no, there's
No, not as per me. You have to make a categorical statement. Then we would ask the FCI to return the EMD straight away.
Yes, ma'am. So, my lord, there is this.
You first answer the question that we have put. Why to go here and there?
Yes, my lord.
You only want your EMD to be returned. You're
Yes, my lord.
questioning the other decision.
Yes, my lord.
So therefore you say
Yes.
that NIT does not prescribe any
Yes, my
such
lord.
mode.
Yes, my lord.
Where
That is my submission.
Show us, where is that statement? Where is that? You can show it.
In accordance to the NIT, that have been mentioned in the writ appeal, my lord.
And why did you not mention it before the learned single judge?
That I have also mentioned.
Discuss.
I have duly mentioned in my.
Where is your petition?
Writ petition or writ appeal?
Show us. Yes, mister. How can you appropriate his EMD?
Madam,
You have cancelled
page
this.
153 of the NIT, madam.
Page 153.
This is clause 2, Roman 2, my lord, down below. May I read it?
Yes.
Parties will be allowed to participate in.
No, you are at page 150.
153, my lord.
153.
153.
Yes.
Down below, my lord, this is Roman 2. Parties will be
What is
allowed
this
to.
document?
Well, this is NIT. Now.
NIT. Okay. No. In the NIT, the terms and conditions for empanelment of technically qualified bulk consumers. Yes.
This is instruction to bidders and terms and conditions governing e-auction, my lord. Parties will be allowed to participate in.
You're reading which clause? Which clause are you reading?
My lord, clause 2, my lord, Roman 2. It is part of the clause 2, my lord. 2 is missing here because parties will be allowed to participate in e-auction subject to the submission of stock declaration clarification in the website so and so as per the GOI dated 12/6/2023 and policy dated 26/2023. A scanned copy of the necessary undertaking along with a copy of a valid FSSI license, a copy of the GST trade tax registration certificate issued from the state concerned and latest stock declaration statement as per Appendix 3 and that at Appendix 4 should be submitted to the concerned divisional office through email at the time of submission of.
Where do you say from the state concerned? Does it mean state of Assam? Concerned state could be any state.
Concerned state, my lord, it is there, my lord, at clause 6, my lord. Page 149, where the GST of state of Assam is required, my lord.
149.
149. Six, my lord, may I read it? PAN number, one of the mandatory requisites for the empanelment of flour mills traders impanel bulk buyers manufacturers of the wheat products to be continued as unique identifying factor. Against one PAN number, only one participation will be allowed in one bid in the state UT in each weekly auction, irrespective of the number of firms registered or multiple GST trade tax registration under the same PAN. Bidding would be allowed in the state against the GST trade tax registration registered in that state UT only. The maximum quantity that a buyer can bid is 100 MP against one PAN and GST trade tax registration of the state UT concern.
Huh? Again,
For-
where is that?
For example, if a bidder is having a GST trade tax registration from the state of Haryana, he can bid for the stocks from Haryana and not for the stocks offered from any other state region of the FCI.
That's right.
However, there is no bar in participating the bid by that bidder from other states if he is having a different GST
Yes.
tax license. So, my lord,
No,
he
look
may
at
have a
this.
number of GST for the different states, my lord. Example has been given, if he is having a GST of Haryana, he will apply in the Haryana state, my lord.
No, no,
But-
no. That's a faulty reading of this. Look at this. You have already read this. How can you read this, I mean, with such a blinkered, approach? It says against one PAN number, only one participation will be allowed in a bid in a state UT in each weekly auction, irrespective of the number of firms registered for multiple GST trade tax registration under the same PAN. Bidding would be allowed in a state against in a state against the GST because
Registered in that state.
in a state because you are FCI, you are a central government organization.
My lord.
So GST trade in a state against GST trade tax registration registered in that state UT
That's-
only.
yes,
So
that-
it could be that is there. It does not refer to Assam only. The maximum quantity that a buyer can bid is so and so against one PAN and GST trade tax registration of the state concerned. As for example, if a bidder is having GST trade tax registration from state of Haryana, he can bid for stocks from Haryana and not from stocks offered from any other state region of FCI. There is no bar in participating in the bid by that bidder from the other states if he's having different GST trade tax registration in such other states. He doesn't have any.
He is having only the West Bengal, my lord.
But then
So
you
he can
can- you
apply
can-
in the West Bengal state, my lord. He has got the bid, my lord, from the FCI for the West Bengal state.
So
But
he has
so far as
applied you-
state of Assam is concerned, he has to have to register under the state of Assam, my lord.
For verification of that district level before he have. It's your feeling which. The option still. EMD 43 bidder bidder with growth. Does not keep. The EMD of all accepted tenders shall be reported within 3 months. Our no interest in the case. और ये भी है till further on. No, you can't keep it.
And therefore, my lord, EMD forfeiture clause is at page 153, my lord. Clause 2, my lord. May I read the clause, my lord? Roman 3.
a bill. No, you'll have to return. Let's see the judgment. How has he dealt with it? He has not dealt with that issue.
By that time, there was no forfeiture of EMD, my lord.
There was no forfeiture of the.
Yes, he
After
came
that-
earlier, my lord, to challenging that he has not given the work, my lord.
But that is there.
Because later on that EMD was forfeited by order dated
This
22.
this would be an additional prayer. This was not argued before the single judge, no?
It
Yes,
was
my lord,
paid,
and in
my lord,
fact-
it was argued. The EMD amount, my lord, I was verbally.
Where in the writ petition, you show that it was argued that your EMD should be refunded.
My lord, in
And
the
it
prayer
was not.
portion itself, it was there, and
Indeed.
yes, my lord, I'll just take a lordship. If your lordship will look upon page number 129 of the writ appeal, my lord, in the prayer portion, I have duly mentioned. Sub para 4. I have also made the relevant submissions, my lord, in the writ petition in regard to EMD amount.
Discharge EMD amount.
My lord, the EMD was forfeited by order dated 22/11/2024, my lord, much after the judgment, my lord, of the single bank.
EMD was forfeited when?
On 22/11/2024, that is not under challenge, my lord.
Exactly, my lord. My lord, we were never given a revocation.
It is there, copy has been given to
Repudiation.
him, all the petitioners.
Counsel, try and understand what he's talking, no? We are inclined to release it.
Yeah.
But you have to overcome this problem, no? So this writ petition was filed much earlier than forfeiting. It was for the time
Yes,
being.
my lord, after 1 year, after the tender process concluded, after 1 year, my lord,
We have put it. So why can't you follow our statements? So this issue was never agitated before the learned single judge, despite the fact that you've said this in your prayer. This was not the issue which engaged the bench. Try and understand. We are trying to find out some way, and you are unnecessarily arguing. You don't have to back talk, no. Try and understand the real principle, the difficulties of the bench in allowing this. This was never argued before the single judge. You're coming here, you're making this prayer for the first time before the appellate court. And that prayer means nothing. Instead of arguing it in a different way, we are trying to give you the relief. You're unnecessarily, applying your mind and spoiling your case. Let us see your forfeiture order.
My lord, that has been given.
Yeah, you understand the difficulties. There is a forfeiture order which is neither here nor there, not on a record. At least if you bring this and make a prayer in a 2 pages affidavit, we will straight away direct.
Copy was given to the petitioner also at the time of issuing the order, my lord. Down below, copy to Sakamberry.
We'll take it on record and look at it. We are taking it on record and deciding. Unnecessarily, for again, he will have to file a petition. In event of non-compliance of clauses mentioned in the table below, in respect of sale of goods by the effective. Non-compliance of clause. No sale of, he was not impaneled even. He was not even impaneled. Where is, this order is defective. You have said that in the event of non-compliance of clauses mentioned in the table below, in respect of sale of food grains by the auction under OMSSD for financial year 2023-24, you have not impaneled him. or you have impaneled, but you have not given him the delivery.
No, he was impaneled in the M junction where to which he has to
M
be.
Yes, M Junction is a platform.
Yes, my lord, that platform, but he has failed to give the GST registration, therefore it was cancelled, my lord. And this AMD was forfeited under clause 2(2) and clause 6, my lord.
The difficulty, Mr. Counsel, is this: without this being challenged, if we pass an order that is unnecessarily challengeable, so you lose out on time. If you don't understand this, therefore we get irritated. We are trying to help you out.
We understand, my lord.
You are Mr. Divyansh Rathi.
Yes, my lord.
You are a young counsel. We are trying to help you out. You have 2 pages of it. On effecting forfeiture of EMD as per the said provision, refund of balance excess of the EMD 1 lakh तक मिला। We will not take this on record. We'll say that this is not the order of forfeiture. This is an order for refund of excess of the EMD, gentlemen. This is not forfeiture. When you say that after on effecting forfeiture of EMD. In fact, you show us the order of forfeiture.
His deposit was 1,10,000 and after which 1,06,000 was forfeited.
You're also in the same, following the same path.
My lord.
Now can we say on record whether it would be correct? And we can say that there is no order of forfeiture.
Hello, let me bring you on affidavit because I have taken this on today morning.
This is what I'm expecting from both of you.
Let me bring you it on record.
But otherwise, we will read it like this. Now look at this. The clause number 2, if EMD, the manner in which EMD deposit is to be made and how it is to be refunded is prescribed in Rule 5 of the instruction to the bidder. So far as Rule Roman 2 is concerned, this forfeiture is only till further orders. That is still for verification. If you read the entire part, this forfeiture is temporary. It is not permanent. The moment you don't give him the supply and you cancel his bid, you have to refund it because there is no provision. There is only one provision where it will be refunded would be if the bidder withdraws his offer or modifies the terms and conditions thereof, or does not keep his offer open for acceptance during validity period, or resigns from the offer, or fails or neglects to observe, perform. Otherwise, there cannot be two provisions existing side by side for forfeiture.
So, my lord, let me bring it on record, my lord.
No,
Subsequent
why do we need it? We will read this instruction to the bidder and we will pass an order.
There might be something, my lord. Let me bring it on record because today morning, in fact,
Up till now,
at 10:15, I got this thing because
tomorrow. You see,
my lord,
somebody's money is such people are not poor people, but then business must run.
hello, on 1st of December.
You also do one thing. You make a prayer additionally, that though it was argued, but it was not effectively dealt with. And therefore now you are limiting your prayer only for the release. You're not challenging the order so far as your cancellation of bid is concerned. You want your EMD back.
Yes.
File a 2 pages affidavit.
I'll do that too.
When the court is thinking something, it's always, see, you'd never know
Yes,
what transpires in the mind of the judge.
yes, sir.
So instead of answering immediately, take time, take pause, and then understand what the court is meaning to say. Correct?
I'll make sure that.
Mr. Rathi, SL. Now we'll make it very easy for you and easier for us on the next date. The appellants have filed the present appeal against the judgment dated 18/9/2024, passed by a learned single judge in WPC number 4749 of 2023. Refusing to interfere with the cancellation of the bid of the appellants. Next paragraph. The Food Corporation of India had issued a notice inviting tender on 7/7/2023 for sale of wheat through e-auction held on 12/7/2023, in which the appellant's bids were accepted and acceptance offers were issued. However, the regional office of FCI verbally informed the appellants that the wheat would not be allotted to them and their EMD would be forfeited. Only subsequently, the appellants were informed that that their tenders were rejected on the ground that their GST registration was from outside Assam, making them ineligible to participate. Though the appeal was filed against the decision of the learned single judge, challenging the decision of the FCI to cancel the bid of the appellants. But Mr. Divyansh Rathi, learned counsel for the appellant, limits his prayer only to the refund of the EMD in case of cancellation of the bid. In support of his arguments, he has referred to the contents of the NIT dated 7/7/2023, which does not prohibit any bidder with a GST registration of outside state, bracket other than Assam, to participate in the bid, except with the caveat that such participation could be for stocks from the state where a bidder is registered for GST or trade tax registration. In the instruction to bidders and the terms and conditions governing e-auction, Mr. Rathi submits, there is a clear provision which permits parties to participate in e-auction subject to the submission of stock declaration certification in the website a scanned copy of necessary undertaking along with a copy of valid FSSAI license, copy of the GST/trade tax registration certificate issued from the state concerned, and latest stock declaration statements declared on the previous latest stock declaration statements would be required to be submitted to the concerned divisional office through email at the time of submission of cost, for verification of the same at divisional office level before issue of release order, failing which the bid would stand cancelled and EMD shall be forfeited. This forfeiture, Mr. Rathi contends, is only temporary, as this clause has been made applicable for all the e-auctions till further orders. This clause, therefore, definitely indicates that the EMD is forfeited temporarily for the purposes of verification of the documents uploaded by a bidder. The manner in which EMD has to be deposited has been provided in instruction number 5 of the instruction to the bidders. Sub-clause 3 whereof illustrates the circumstances under which the EMD of a bidder could be forfeited. It says that EMD furnished by the bidder shall be forfeited if the bidder withdraws his offer, shall be forfeited, semicolon. A, if the bidder withdraws his offer or B, or modifies the terms and conditions thereof, semicolon, or does not keep his offer open for acceptance during the validity period, semicolon, or resiles from the offer, semicolon, or fails or neglects to observe / perform any of the obligations under the contract, semicolon, ED marking karte रहना, or violates any of the terms of the contract subject to clause 10A bracket 3 and 10A bracket 5, bracket 6, Roman 6. Subclause 4 of Rule 5 further mandates that the EMD of all unsuccessful tenderers shall be refunded within 3 working days from the date of issuance of acceptance letter to the successful bidder. However, no interest shall be payable for delay in refund of EMD, in any case. The contention of the appellant, therefore, is that in any view of the matter, whether the action of the FCI in cancelling their bids was justified or not, the EMD deposited by them has to be refunded, because neither have the appellants withdrawn their offer or modified the conditions, or have not kept their offer open, or have resiled from any one of the terms of the contract. They have been unsuccessful because of their registration, GST registration being from a different state than Assam. This leaves the FCI with no justification for forfeiture of the EMD. During the course of argument, Mr. B.K. Singh, learned advocate for the FCI, has produced before us an order dated 22/11/2024, indicating that the excess of the EMD forfeited was being refunded. It appears that there is no order of forfeiture of EMD on record. We have also noticed that the learned single judge only dealt with the issue relating to the GST registration, especially whether the same is mandatory. Though a specific prayer was made in the memo, in the writ petition for discharge of the EMD in the alternative, the same was not addressed by the learned single judge. Mr. Singh, learned counsel for the FCI, however, contends that the EMD was forfeited on 22/11/2024, which statement does not appear to be correct from the document which has been produced before us. The communication dated 22/11/2024 is only a declaration of the refund of the excess amount of rupees 3,750 on effecting the forfeiture of EMD. Mr. Singh submits that he shall, on the next day, bring on record the order whereby the EMD of the appellant was forfeited, and Mr. Rathi too submits that he shall be filing an affidavit for modification of the prayer in the present appeal. Now, this will be, the records will be straightened, and then we have to pass orders, whatever we feel like. But we re-notify on December.
9/12. Item 22.
May I appear, Lordship?
Yes.
Lordship, I have filed my wakalatnama on behalf of the respondent number 4 and 5 today. Lordship, as per your Lordship's order dated 13/10/2025.
I had asked the two lawyers who are not giving no objection. Have they come?
No, no,
Just for counsel.
it is, yeah. कीजिए मेरा वो,
Oh. I had issued court notice to them. But anyway. There is no report regarding service of notice on the two learned advocates who had refused to give no objection on demand by response number 4 and 5. This court only wanted to counsel them that an advocate ought not to sit over the file of his client if the client wants to engage another lawyer. Be that as it may, today, Mr.
M. Das.
M. Das, learned advocate, has filed his wakalatnama on behalf of response number 4 and 5 and seek some time to respond to the appeal. In case any affidavit on their behalf is required to be filed, that may be done by the next date. Re-notify on so and so. Interim order in the meanwhile shall continue.
Lordship, can I ask for the longer period? Lordship, we have to restructure the entire file.
February.
Yes, what do you want?
Lordship, I was praying for a longer time so that.
No longer time.
We have to restructure the file, Lordship. We do not have to brief with us. We have to get copies and all.
How long will it take?
At least 2 weeks, 3 weeks.
We are, and have you heard the date?
No, Lord, no.
Then
I'm sorry.
give a date.
6 February.
You require longer time.
No, Lordship. Sufficiently enough. Oblige, your Lordship.
All right. Problem.
Item 23.
Nobody has been appearing in this matter for a while. It appears that the petitioner has lost interest in this matter. The petition is dismissed as dismissed for non-prosecution. Unnecessary. Pesticides. But there were certain issues which could be addressed.
Yes,
Some framework, how to go about. But then
in fact, during the pendency, many things happen.
Item 24.
24 and 25 are same issues. Huh? Yes.
My lord, the subject matter, my lord, is the Venture Sanskrit School, my lord, and our school was duly examined and inspection was
What
done.
can be done now?
My lord, now, my lord, it seems, my lord, the university is looking after, my lord.
They,
I heard, my lord, but I have no notification, nothing, my lord.
what did you hear?
I hear, my lord, that board has been taken away by Sanskrit University, something like.
I think your job is done now.
Lordship.
Leave it as it is. Don't press this petition.
Lordship, I am leaving out your lordship, my lord.
No, don't
Subject, my
press
lord,
this.
I should get some relief, my lord. I am,
Leave.
I am hesitating. I have donated my land. School is on
We
my
would
own.
say that you withdraw this petition for the present because some developments have taken place. We will give you the liberty to come back to us again.
Lordship, that will do.
Can I have your name, please?
J.I. Barhoya, my lord. It is reflected in the cost.
Mr. J.I. Borbhoya, learned advocate for the petitioner, submits that he has been informed that some developments have taken place which in long run would redress the grievances of the petitioner. So he thus does not press this petition for the present. However, he seeks a liberty from the court to approach this court again, seeks a liberty to approach this court. However, he seeks a liberty to approach this court again in case his grievances are not redressed. Dismissed as not pressed.
Closed, my lord, instead of dismissed, my lord.
Dismissed as not pressed. With the liberty aforesaid.
Lordship.
24-25.
You are appearing in both the matters.
My lord.
Both separately, pass separate orders.
Item 26 and 27.
May please, your lordship.
Yes.
The lordship, this matter is originally posted on 20th Jan. I believe the bank has made a mention for listing of this matter.
Louder.
Your lordship, these matters were originally listed on 20th January, your lordship, but I believe the bank has made a mention in item 26 for listing of the matter.
Yes.
So let them begin, but before, with the lordship permission, before they begin, can I submit one order passed by your lordship, which has a bearing in item 26?
No, you are appearing for whom?
I am for the appellant, lordship.
Already took continuous. I mean, how, when the matter was fixed for 20th of January, how has it come today?
Your lordship, a bit urgency in this matter because your lordship, because of the order dated 12/2/2025. Thereby, we have been granted a.
No, but did you mention it? Did we allow the mentioning?
Yes, sir.
How was it listed?
We have mentioned in the regular. Court.
In this court.
Yes,
Before this court?
yes, sir.
Did you say that a date has been fixed?
Date has been fixed, yes, sir.
Did you say that?
Your lordship, my junior has made a mention, so I didn't remember that.
No. That's not done.
Yes.
If you want a preponement of the case, you have to file an application. We readily allow such application,
Yes, I'll file.
but then not like this.
I'll file. My mistake.
You file an application only then.
Yes, sir. I'll file.
Take down.
Your lordship, but only one short prayer if allowed, your lordship. That is, your lordship, that the property has been sold, but because of the department, we could not able to deposit the encumbrance. That is why the urgency is only.
No, the issue is something else.
Yes,
Yes.
your lordship.
The issue is that they have their first charge. And that is there in the memorandum.
No, your lordship, I am not on the charge issue. Your lordship, I am not on the charge issue. I am on the rule 9(7) only, your lordship. We are not denying that they do not have the encumbrance.
With your lordship permission, may I submit one fact, your lordship?
Yes.
Your lordship, subsequently, the workers have also filed a writ, which have heard by your lordship, where they have challenged the auction notice has been defective as per the rules. The lordship was pleased to issue notice. However, interim was not granted because only on the observation because interim is already here. So this matter has to be heard with that matter, if I may say. I have that order, your lordship.
Altogether, your lordship, 3 matters now.
Item 27 has no bearing with the other
Yes.
matter. 20, for some strange reason, it has been tagged along.
So
8022 is on a different issue altogether.
yes, that can be detected 27 if
In
my.
fact, it's a single bench matter because it pertains to the proceedings related with the RDB Act.
Now we'll hear all these petitions together.
Yes.
Here.
And one more matter.
Any date fixed here?
Here, your lordship, the subsequent order is
27/10.
27, and it came up, your lordship. Next is fixed on 12/12.
12/12.
Yes.
So I think this also will
12.
pass an order.
Yes.
So this case was directed to be listed for consideration on 20th of January of 20th of January 2026. But it appears that on oral mentioning, this case has been listed today. Let this case be listed along with WPC number 4994 of 2025, which has been directed to be listed on
12 by order dated 27/10/25.
on 12/12/2025.
And your lordship is another matter is there, 6560 of 2023, same matter, your lord. With the EPFO.
Let WPC number 6560 of 2023 be also listed on the same date along with the aforementioned two petitions.
So the 27 may perhaps be redacted.
We'll see it on the next day.
Obliged, Your Lordship.
Item 28 and 29.
Lordship,
55 and 58.
Lordship, pleading is complete.
Where is Mr. Chanda? Mr. Chanda, did you inform 20, respondent number 25 and 58?
Yes, my lord, they have given the consent.
They have given you consent. Yes. So it is, the notice is complete.
Lordship, the matter may be fixed for hearing, Lordship.
Why not today?
Lordship, Lordship, can you see that affidavit filed by the respondent, Lordship? I have to go through this, Lordship.
My lord, they are
Very voluminous, Lordship.
2019 examination.
Get the file only a day before, no?
My lord, 2019 examination. It has been cancelled without the approval of the
On
headquarters.
any hearing.
And they have been declared pass. They have been declared pass. It is a 2019.
Mr. Chanda, you don't insist for all this. You have a bad case. I don't know why he is not arguing. Unless you say something which will deflect our line of thinking.
Any hearing date, Lordship. I mean,
What any date?
because I have to go through their affidavit, Lordship.
Nah, that is not done.
That is not done because very voluminous, Lordship.
Take that. Response number 25 and 58 were reported to have not been served. However, on our request, Mr. M. Chanda who appears for rest of the respondents. Mr. M. Chanda, learned advocate who appears for rest of the respondents, communicated with them. And today, Mr. Chanda holds power on behalf of response number 25 and 58 also. With all the respondents having been served, the matter ought to have been argued today. But for some reluctance on the part of Mr. Chakravarti, learned central government, learned council. I'm not saying anything wrong. Anyway, please, let it not be like this. Since all the respondents have been served, the matter is ripe for hearing. Mr. Chakravarti, learned advocate, on behalf of the petitioner, Class Union of India, seeks some time in the matter for effectively addressing this court. Now, this is all right?
Lordship.
This is not stigmatic or something?
No.
Let this matter come up for consideration. We were inclined to pass the earlier order. That for your reluctance, the matter has not been argued. But you people only go outside and say that time is granted in all cases. Anyway.
My lord, early date.
January.
My lord, they are very much.
January.
6th of January, early.
6th of January. 6th of January.
All right.
Item 32, 32.
Your Lordship may peruse order, this is 39/2025.
Who appears for the other side? Mr. Khatnia?
Yes, yes,
Yeah, what do you,
yes, my lord.
tell us, the order is,
Yes, my lord. We have filed our affidavit, my lord.
you have filed your affidavit.
Yes, my lord.
What have you to say?
Answering the issue framed by this honorable court, my lord. The thing is that, my lord, on the date of application, they are not eligible
That's right.
because although it's an additional requirement as per the advertisement, but in the statute, it has been mentioned that this,
In the format, you don't list these documents to be uploaded.
yes, my lord.
Therefore, we would presume it to be a qualification which on the date of consideration they must possess.
No, my lord, because it's a qualification, since it's a qualification.
Tell us any law which says to the contrary. Give us any law which says to the contrary. You're asking for these information, for uploading of this information, they have uploaded it.
But my
You
lord,
don't know.
my lord,
Suppose they had the additional qualification before,
yes, my lord.
but unless you ask those documents to be uploaded, they shall not. So today they have this application, they have this qualification. So therefore, your intention in the advertisement is absolutely clear. Unless you can show from any case law that notwithstanding this, we will not consider that.
My lord, kindly come to page 77, my lord.
You answer, no, why 77? You answer,
Because, my lord, in page 77, this is their application form. In application form, they have mentioned, my lord,
application form in page.
page 77.
Consider their application. Let them pass or fail.
My lord, I am referring, read appeal number 273, my lord. Because in that file, we have filed our response, my lord.
This is
273.
273, yes.
Yes. In the application form, my lord,
Yes, application form, tell us.
16, column number 16, my lord.
There is no numbering.
No number, my lord. It starts with language as one of subject if any other than MIL.
Language of language of MIL, language HS. This.
Second one, language as one of subject if any other than MIL. So they have mentioned as diploma in Assamese. But on the day of submitting the application, they do not have that diploma, my lord.
No, that is his argument, that yes, they on the day of submitting, they have said diploma in Assamese, which is a wrong information.
Yes, my lord. The information they were given were wrong, my lord. And on that wrong information, my lord, we cannot consider their application, my lord.
Mr. Bhattakur, here,
Lordship, there is,
you should have left it blank.
no, your Lordship will kindly say at the relevant point of time, we are doing our diploma, your Lordship, in Assamese, your Lordship.
You should have said diploma in Assamese, pursuing diploma in Assamese.
No, that your Lordship, ideally I should have, but your Lordship, ultimately your Lordship will kindly see, your Lordship.
No, we are inclined. But for the fact that the law is against you, any wrong information in the column, you could have said that person. On principle, we are agreeable to your submission that if certain documents which are not asked to be uploaded, you have not uploaded it. Suppose even if you had diploma in Assamese, you had the degree in your hand, even then you would not have uploaded.
Lordship.
No, but they have rejected your case not only on the ground that it has not been uploaded, and others have, but then you have made a wrong statement in the application.
That your Lordship, from the at least your Lordship, where they have rejected my candidature, your Lordship, that is not reflected from that. That has been developed by them, your Lordship, subsequently, that we have made.
Where is the rejection? Where is the rejection order?
No, there is no such order, your Lordship. It only says there is a rejection slip, your Lordship.
Any wrong statement leads to the complete,
No,
you have to be shut up.
No, that is why we have done this. Your Lordship will kindly see. Your Lordship, number one, your Lordship, it is not required to be uploaded. Number one.
No, that we have said so in our order dated
What is
29.
coming from your Lordship mouth, your Lordship?
We are on a different issue.
Lordship,
Specific
I will try to explain it, your Lordship. Secondly, your Lordship, we were continuing with that. Thirdly, your Lordship, which you have been part of our writ petition, your Lordship. Earlier recruitment process, your Lordship, they have allowed similar candidates, your Lordship, to be appointed. Number one. That's the reason why, your Lordship, we have put that, your Lordship, that we are continuing, pursuing. But it will be, your Lordship, too technical, your Lordship, to be, your Lordship, to reject that on that ground. Because
No, Mr. Bhattakur, It will not be too technical. You know, you have to show that this is the difficult position. Had you left it open, we would have allowed your application.
No, your
straight away.
lordship will kindly see, your lordship. Diploma in Assamese, your lordship, I have been told, your lordship, that there is no such option that we can write, your lordship, that we are pursuing, your lordship. We will have to click, your lordship, and on the basis of that click, your lordship, it will
So therefore,
automatically
then
print out.
you're only supporting their case. That therefore this was an important eligibility criteria.
No, your lordship, that is, your lordship will kindly see there, only in this, your lordship, language, MIL, HSLC or equivalent examination, Hindi,
The
then
law
your
is otherwise.
lordship.
You know the entire series of, you know, case laws. It says that on the day of the application, eligibility requirement, if that is not there, we
That
would.
is your lordship settled position, your lordship. I have no quarrel with that. Your Lordship. My
difficulty is that
only,
how do we derogate from that?
lordship, my
principle?
only question, my submission will be, your lordship, whether it will be your lordship's a mandatory condition or not, your lordship, or an ancillary, that will be decided by the object it sought to achieve, your lordship. Now, what is the purpose? Why I need to have that particular diploma, your lordship? It is purpose is, your lordship.
Have you challenged that eligibility
No,
criterion?
because
You possibly can't.
no,
The employer knows. The
that is why,
university knows.
No, your lordship, what I am submitting, your lordship will kindly see, your lordship. The purpose for having this, your lordship, is so that ensure that we can converse with the students, your lordship. That is the only purpose.
That is something, there was one case in which this example was given, that for the post of, DFO or forest guard, the requirement was that, the eligibility requirement was that he should have some training in geology or geology or something. That was held to be bad, but not otherwise.
Lords.
This is your conversational skills.
That is what,
Because you are being appointed as a teacher.
lordship, that is what I am submitting, your lordship. That for that, your lordship, that requirement of having it before, your lordship, that probably.
Mr. Bothakur, can you challenge this now when you have?
No, I can't. I am not challenging it at all, your lordship.
Then
I am what I am submitting, your lordship.
then
This is
then straight away this is a wrong information.
that this is a condition, your lordship, which is, your lordship, ancillary in nature, your lordship, that can be
Just
reflected.
a minute, let it be left to them. Now, what do you say? They have acquired it.
They have
Not
it,
on the day. The
Well,
cutoff
kindly
date
come-
is most important.
Kindly come to page 68. There is a condition in the advertisement also, my lord. If any information is wrong, my lord, we can reject that candidature.
That's an easier course of action to be adopted by you. Rejection is your favorite pastime. 68.
Yes, madam. Authorities reserve the right to cancel the candidature of any candidate as and when any ineligibility condition is detected. If any information declared by the candidate is found to be false at any stage, the candidate will be penalized as per prevailing law.
If we had the powers under Article 142, we would have allowed this. What do we do?
The only thing, your lordship.
Despite our best of intentions, we cannot help you. See, read our order dated 3/9/2025. We had made it very clear.
Lords.
Your not uploading it would not have been fatal. Your wrong information is fatal.
Lordship, whether that will amount to, your lordship, wrong information, your lordship.
What could be more incorrect
Lordship,
information than
it
this?
would have been, your lordship, had without having even going for that, your lordship, we have written that diploma. Then, your lordship, it would have been a
You
wrong.
Look at it from another angle. So we are inclined to allow, but then we are getting stuck up here. Now, the moment the application form requires you to fill up that column,
Lords.
that means it is the qualification, the eligibility criteria. Without this, you are out. If this column would not have been there,
It says, your lordship, language as one of the subjects, if.
suppose you did not have, you'd have left it vacant. And they would have rejected your application.
Then, your lordship.
Then we could have considered that this is an additional qualification. We would have tested whether this qualification is necessary for the employer to make it, mandatory. The filter level.
Lordship, if you look at the entire
What
circum-
law do we apply to say that this wrong information on the day when you applied the form, you did not have diploma?
My
You write you that you have diploma.
My humble submission will be this, Your Lordship. The fact that, Your Lordship, they have in the previous recruitment process considered the cases of the present candidates like the present petitioners, and even in the BTC, under the state of government, Your Lordship, they have appointed similarly situated candidates.
So
that-
please don't draw parallels with BTC.
No, that's why, Your Lordship, because it is under the state.
In the last recruitment process in Assam, if you say, we will ask them if they can consider.
Yes, Your Lordship, that they have done, Your Lordship. They have
Yes,
done, and
No,
that
my
is.
lord, no, my lord, that is a wrong statement. BTC may be there, my lord. In case of our, my lord, state, my lord, it was not there, my lord.
In fact, I have, Your Lordship, annexed two copy of Your Lordship in my writ petition, Your Lordship will get it.
Mr. Thakur,
Lordship.
we don't have the powers under 140.
No, I know, Your Lordship. I know, Your Lordship. But Your Lordship, had it been, Your Lordship, any other certificate, Your
Now you
Lordship, like
see our
P.Ed.
intention. We have kept
Lords.
13 posts reserved for you.
Lords.
But today we don't think we can allow this.
Lords, I will leave it up to Your Lordship, but Your Lordship, that will be my humble submission, Your Lordship, that will be too technical. Otherwise, they are qualified.
Don't-
Otherwise, they come
It is,
under.
it is not hyper-technical approach that we are adopting. We are trying to help you out in the
Lordship,
best possible manner
I bow down, Your Lordship.
because you are a qualified person. You should not be shut out. I don't know why Mr. Khataniyar's department is insisting for this. But then technically, we have our own mandate.
Lords.
We can't go beyond that.
Lords.
Right?
Lord.
And especially this court, I mean, we are very particular. We know our remit.
Lords.
Beyond the remit, we are not passing any order despite, lawyers trying to tell us that, yes, the High Court has powers under Article 226. But we are very careful about our remit.
Lord. Otherwise, Your Lordship, the date of attaining of qualification is, Your Lordship, definitely, Your Lordship, last date. That. But my only.
They would be the ultimate losers
Lords.
if you are good in academics.
My only, Your Lordship, and in fact, Your Lordship, page 203, Your Lordship,
All the three appear.
203, Your Lordship,
You are
In-
appearing in all.
all, Your Lordship, in writ appeal number 276, Your Lordship will find. After the recruitment process, they have appointed when they could not submit, then, Your Lordship, the candidature was rejected, Your Lordship. That was the procedure they have all along been. That is why, Your Lordship, the past practice is, Your Lordship, is this.
कुछ बताइए, कुछ show us any law so that we get strengthened. We pass an order.
No, only on past practice, Your Lordship, we can show one, Your Lordship, that is Suresh Nathan, Your Lordship. That Your Lordship will kindly come to page 203 of my writ appeal, Your Lordship, 276 writ appeal number. 273, 122. 276. Item 32. Page 203, Your Lordship.
इसमें नहीं है. Page 121.
203.
373 till 121.
Lords.
क्या है ये?
125. This has created, Your Lordship, legitimate expectation on our mind, Your Lordship. This practice, Your Lordship.
And this is helping you. This is not taking you anywhere.
Lords. Ultimately, Your Lordship, what they did in last recruitment process, Your Lordship, that, Your Lordship, they have allowed joint appointment orders were issued. Then, Your Lordship, they are directed to submit these diploma certificates. Those who could not, their appointments were cancelled later on, Your Lordship. This is the practice, Your Lordship, and that is why, Your Lordship, neither in the SOP nor in the, Your Lordship, in the application form, there is anything about this, Your Lordship. That was the intent of when the advertisement was issued, Your Lordship. Subsequently, Your Lordship, they have, Your Lordship, developed this, Your Lordship, and then, Your Lordship, they have decided to cancel it, Your Lordship. This is the and that's why, Your Lordship, neither in the SOP is also very clear, Your Lordship. They have specifically referred to B.Ed, everything, but not about, Your Lordship, this.
Because all the case laws will tell you that the cutoff date is the date when you should have the eligibility.
Lordship, that, Your Lordship, I will not go, I have nothing on
We
that.
can't-
That is absolutely.
We can't, even we
Yeah.
can't.
Only on this, Your Lordship, that, Your Lordship, this requirement, Your Lordship, we have, Your Lordship, mentioned it as a diploma in Assamese only because, Your Lordship, they have had the practice, Your Lordship, number one. Number two, Your Lordship, they have not, Your Lordship, made any mention that this should be uploaded. Then, Your Lordship, therefore we have did it, Your Lordship.
We are not able to find any way.
Lordship.
Take them. We have heard Mr. S. Thakur, all the three appeals have been taken up together and are being disposed of by this common justice. We have heard Sri S. Thakur, learned advocate, learned advocate for all the appellants, and Mr. N.J. Khataniar for learned standing council secondary education for the respondents. An advertisement was issued by the respondents on 26/12/2023, inviting applications from eligible candidates for filling up 7249 vacant posts of graduate teachers bracket arts, comma, graduate teachers science within bracket, comma, graduate teacher Hindi, and graduate teacher Sanskrit of different provincialized secondary schools under the Directorate of Secondary Education, Assam, in the scale of pay of rupees 14,000 to 70,000, including grade pay of rupees 8,700 per month, bracket under pay band 2, plus other allowances as admissible under the rules. The minimum educational and professional qualifications for direct recruitment in the post of graduate teachers, bracket arts and science, have been specified, which includes degrees from recognized university with at least 50% marks either in graduation or post-graduation, bracket or its equivalent, and B.Ed degree from National Council for Teacher Education recognized institutions. In addition to these academic and professional qualifications as referred to in the advertisement, which is in consonance with the Assam Secondary Education bracket provincialized schools bracket close service rules 2018, the candidates under the advertisement are also required to satisfy other criteria, few other criteria, semicolon, one being that in case of application for the post of Assamese medium schools, the candidate must have passed HSLC or equivalent examination with Assamese language as one of the subjects, or have diploma in Assamese language issued by a home Sahitya Sabha, or he/she should have studied up to HSLC level in Assamese medium school. Likewise, in case of application for the posts in Bengali medium school, candidates must possess HSLC or equivalent examination, possess certificates of HLSC or equivalent examination with Bengali language as one of the subjects, or a diploma in Bengali language issued by Barak Upatyaka Banga Sahitya or Sanskrit Sammelan, or he/she should have studied up to HSLC level in Bengali medium school. The contention of Mr. Talukdar Sorry, why do I always refer to him as Talu? The contention of Mr. Bhattakur, learned advocate, is that this proficiency in the language is only an additional requirement, and it is not necessary for a candidate to be in possession of such certificate / diploma on the date when the application form is filled. This additional qualification, he submits, could be acquired at the time of final determination of his candidature. Otherwise, documents pertaining to such additional qualification would have been required to be uploaded in the list of documents supplied under the advertisement. In the list supplied of the documents which are to be uploaded, there is no requirement of uploading any such qualification, any such language proficiency qualification. On the basis of the aforenoted list of documents to be uploaded at the time of filling up of the forms, Mr. Bhattakur submits that there should not be any insistence for a candidate possessing such qualification on the date when the forms were filled up by them. The cutoff date is only for such documents, on the basis of which an applicant presses his eligibility. And those are documents reflecting those criteria were only required to be uploaded at the time of online filing of the application. On the contrary, Mr. Khataniar, learned counsel for the respondent, submits that the application form to be filled up by candidate for recruitment clearly demands the information whether the candidate possesses the diploma in language as one of the subjects, if any other than MIL. This clearly reflects that such proficiency in language, such certificates of proficiency in language is an essential qualification which a candidate must possess on the date when the application form is filled up. Of that apart, it has been submitted that the appellants have furnished wrong information, wrong/erroneous information in their respective application forms by declaring that they are in possession of diploma in the concerned subject, while the fact is that they were still pursuing the course and had not obtained the certificate. Precisely for this reason, their applications were not sifted for consideration. Sifted means SIFT. Sift it for consideration. Rekha Chaturvedi versus University of Rajasthan, 1993. Nikalo. Rekha Chaturvedi versus University of Rajasthan, 1993, Supplementary 3, SCC 168. And Ashok Kumar Sharma and others versus Chandrasekhar and others. Yeah, 1997 for SCC 18, but this has been reviewed by the Supreme Court. उसी नाम से होगा Ashok Kumar Sharma and others. And the third citation is, anybody noting now?
Yeah.
Third citation is Diptimai Parida versus State of Orissa and others. 2008, 10 SCC 687. निकाल के रखना तब तक हम लिखाते हैं. Yes, what did I say? I not obtained this. In Ashok Kumar Sharma and others. Citation you will get versus Chandrasekhar and others also. The Supreme Court reviewed its earlier decision and held that the candidates who are not qualified and are not entitled to apply on the last date of the application cannot be permitted to participate in the recruitment process. Any person acquiring prescribed qualifications subsequent to the prescribed date would not fall in the category of eligible candidates. Similar view has been taken by the Supreme Court in Diptimai Parida versus State of Orissa and others, 2008, 10 SCC 687. The rationale behind such proposition is that if it were known that persons who obtain the qualification after the prescribed date also could apply, then perhaps other candidates also would have applied. Stop. In that case, allowing the applicants without the essential qualification prescribed in the advertisement would be unfair to such other persons who would not have applied, thinking that they do not have the requisite essential qualification. Application. First, the learned single judge relying on the aforementioned principles enunciated in Ashok Sharma, Rekha Chaturvedi, and Diptimay Parida Supra, rejected the claim of the appellants. Rejected the claim of appellant. We are in agreement with the aforementioned decision of the we are in agreement with the decision of the learned single judge. For we find no reason to deviate from the settled principle of law that the essential / basic qualification, which is the eligibility criteria, cannot be tinkered with, and it has to be reckoned on the last date of filling up the application form. Decidedly, the appellants did not have the requisite qualification of diploma or proficiency certificate in the language on the day when the applications were filled up by them. In expectation of acquiring such certificate, the appellants had applied, and in some way or the other, the information provided by them in the application form was application form is not factually correct. Considering the rationale behind reckoning the eligibility criterion on the date of the filling of the application form, which the appellants do not possess, we are left with no option but to dismiss their appeals and sustain the judgment of the learned. The order accordingly, all the appeals are dismissed. We are not happy to do this, but what to do? We are not at all happy to do this. वो हमें अशोक शर्मा वो वहां दे देना करेक्शन के समय I will make necessary.
Deeply obliged.
Supplementary list, item 36 for admission.
इसके बाद supplementary है क्या? Okay.
My lord,
Yes.
in this case, my lord, Mr. I. Chaudhary is leading our this case.
Mr.
Mr. I. Chaudhary, my lord.
Mr. Indranil Chaudhary.
Yes, my lord, lordship may fix at any date, my lord.
Like
My lord, the matter can be disposed of, my lord. We are agreeing to a representation, my lord, which has been pending.
That, my lord, lordship will.
One man adapt.
when will he be available?
My lord, lordship may fix after 1 week any day, my lord.
Because they
As
complicate.
prayed for on behalf. All right, Mr. Bhuya, you took time in the morning.
No, my lord, my lord. I am agreeing to
I-
my lord.
As prayed for on behalf of the appellant,
Yes.
re-notify on and agreed to by the learned counsel for the respondent, re-notify on, give a date in the last November.
My lord.
28 November.
Oblige.
Daily list for hearing item 33.
ये बहुत लंबा चौड़ा है। That is not here. I can't get. Yes, yes. Whatever. Mr. Das,
Yes, ma'am.
you are very selective in supplying the documents.
No, my lord.
In my brother's brief, there are list of dates in mine.
No, it was, I gave 2 copies, but I'm so sorry, my lord. But I'll just, my lord, pass on my copy, my lord.
I may have.
I'm so sorry, my
misplaced
lord.
it.
I filed 2 copies.
I'm sure it is not intentional.
No, my lord, never.
Yes.
So this is the short lordship.
Yes.
So this is your lordships wanted on the second last occasion.
Yes.
After hearing, my lord, here the petitioners before your lordships were initially appointed in the year 1993-94.
Hmm.
And they're still continuing for last 30 years.
Hmm.
And they approached Learned Tribunal. Learned Tribunal dismissed their cases while considering a series of matters.
Hmm.
And I'll just refer to the relevant portion.
Hmm.
Learned, the issue was that, my lord, we produced documents before the Learned Tribunal establishing our claim. The Learned Tribunal, my lord, rejected our case, saying that we failed to produce the original. Now, during the course of this proceeding, this honorable court was pleased to direct the respondents that you file an affidavit to that effect. The respondents filed the affidavit saying that they don't have the original. So that is the only reason. Otherwise, there is no iota of doubt that we have completed 240 days in all the years, my lord.
They are still continuing.
Yes, my lord. We are still continuing.
And the tribunal had earlier passed an order on a different way.
Yes. And here in the order.
Yes, Mr. Pathak,
My lord.
you're asking for something more from them. You are the employer, you don't have the records, you're asking, they have given everything that they had.
My lord.
And you're still,
Our contention initially
you
was
possibly
that
can't do that after.
why those documents could not be found is that they
Yes.
were some documents furnished by them to the tribunal which are photocopies, and these are documents issued by some
Your
engineer
BSNL,
or
no?
somebody
Your
who is not the
BSNL.
competent authority to issue such documents.
No,
So
no,
there's no
your
file
BSNL.
number.
Without these persons, you cannot run the telecom.
That definitely, my lord. The issue now is that, my lord, at that point of time, the
Give them
cutoff date was
temporary
1/8/98. The fact remained that
They are not asking them to be regularized. Give them temporary status. You can't shy away from this. This is unfair. This is unfair on the part of an employer.
I understand.
And the tribunal's judgment is contradictory.
Exactly.
What I find is that, my lord, the
Tribunal
initial part, no doubt there is some doubt as to the number of days of engagement. But then what
All
has
right,
happened
we have
subsequently,
heard
25, 26 years they have worked, my lord,
Yeah.
no doubt. That have
We
probably
have heard
created some other
Mr.
right now.
H. K. Das, learned advocate for the petitioner, and Mr. P. Pathak for response number 2 to 7. Judgment is reserved.
Not only one prayer. Not only one prayer. My lord. By now they have completed, few of them will be retiring in December. So your lordship will kindly consider
that they get their benefit from with retrospective effect. Because otherwise, my lord, after retirement, their pension and all those things. In fact, in Dharam Singh also, the Honorable Apex Court since 2002 granted benefit since 2002, my lord. As far as pension is concerned, we are not a pensionable establishment. So only EPF, my lord, EPF linked scheme pension.
Let's see,
My lord.
let's see, we have to go by Dharam Singh.
My lord.
Yes.
And there is another case after Dharam Singh. What is that?
No, Dharam Singh is the latest, my lord. Earlier, Jago was there.
Prior to
Jago,
Dharam Singh,
and
Sripal
then
and
there is
Jago.
No. One more. Ay, where is my compendium? There is one more. Mr. Chaudhary at.
No, no,
Sripal.
Sripal.
Sripal. Yes. Mr. Chaudhary only had shared that.
Sripal is prior to Dharam Singh, my lord.
It's
Dharam
prior
Singh,
to Dharam Singh.
yes,
Okay.
Dharam Singh referred Sripal.
All right, but these three cases.
Yes, these are the three cases. My lord, in my list of dates, I have given the number of days also when they completed 240 days. Much obliged.
You had initially supplied list of dates to my brother.
It's not like that. Highly obliged.
Right.
I'm sure, Mr. Das, you are not taking such a statement seriously. I mean, this is.
No, never, my lord. Never. Much obliged.
Obliged.
क्या है ये केस? Since when has the state been contesting the remand orders? Since when?
Melody, in my humble submission, the interference with the punishment, Melody, your lordship is where interference with the punishment only when it shocks the conscience of the.
I mean, no, Ranjit
Here,
Kumar,
Ranjit Thakur.
Ranjit Thakur,
Thakur.
what is it?
My lord, here the sympathy that has been shown, possibly misplaced because the learned single judge has not come to a finding that the punishment is.
Mr. Mazumdar, if I were the disciplinary authority,
My lord.
I would have only cautioned people. Exactly. Look at the charge. They did not tag.
No, my lord,
The case diary.
I can show my lord, your lordship.
Remand order is generally not.
He written.
You show me, Mr. Chaudhary, where are those judgments where? they
I have
demand-
brought BC Chaturvedi.
और बहुत पुराना है. Well, that is too old.
Well, Chaturvedi has been subsequently.
I relied upon a latest judgment before, which is quoted in the Supreme Court judgment. Sorry, than a single judge's judgment itself.
For us, the judgments of Patna.
Sikri se.
Heavy judgment to court.
2013 KNS system. Kindly.
Bring your judgments on the next day.
Yes. So
Remand, we don't remand, it's unless it is perverse.
Yes.
Unless it is perverse.
So far as findings are concerned, my lord, that the charges are proved, the learned single judge has not said anything, has not interfered. There is some degree of negligence.
Inquiry.
Now, so far as the punishment is concerned, my lord, there has to be some finding that the punishment is too harsh or it's not proportionate.
See, the difficulty is that if the punishment would have been sustained by the single judge,
I know.
it would have been easier for us. We would have set aside that judge.
Yes.
And now, with this mindset, you argue.
I'll argue with that mindset.
Judgment to go to the left.
Oh, no, Mr. Chaudhary doesn't press that. Remand, forget it. You don't press your.
Just Milord.
Well, one paragraph from this 2013 10 SSC. Lordship, sir, where I'm just for my.
I'm not aware. Yeah. See,
for my
we know the
satisfaction,
principles, but it has to be cited before us to.
Well, I'll
make
cite.
use.
I'm citing one judgment, Lordship, just have a look at
Yes.
this. Page 2013 10 SSC 106. Here, my lord, BC Chaturvedi has been referred with approval.
This is Deputy Commissioner Kendriya Vidyalaya Sangathan.
My lord, it has gone from the state of Meghalaya. With para 8,
Deputy Commissioner of Health,
paragraph 8, my lord.
Kendriya Vidyalaya.
May I read, madam? The order of the appellate authority while having a re-look at the case would obviously examine as to whether the punishment imposed by the disciplinary authority is reasonable or not. If the appellate authority is of the opinion that the case warrants lesser penalty, it can reduce the penalty so imposed by the disciplinary authority. Such a power which vests with the appellate authority departmentally is ordinarily not available to the
2013
court
TNSS.
or a tribunal. The court will, while undertaking judicial review of the matter, is not supposed to substitute its own opinion on reappraisal of facts. In exercise the power of judicial review, however, the court can interfere with the punishment imposed when it is found to be totally irrational or is outrageous in defiance of logic. This limited scope of judicial review is permissible and interference is available only when the punishment is shockingly disproportionate, suggesting lack of good faith. Otherwise, merely because in the opinion of the court, lesser punishment would have been more appropriate, cannot be a ground to interfere with the discretion of the department authority. This is my only submission in the entire case, my lord. Lordship will see the abrupt finding in the judgment of the Lordship will kindly allow me to point out that part. Then I'll leave it to law.
No, don't leave it to us. Please argue your theory.
My lord will kindly straightway turn to page 183 in our appeal, my lord, which is writ appeal 46 of 2025. Second one. Otherwise, my lord, page 183, my lord.
2007, 7 SCC 20.
Page
183, paragraph 41 at the bottom.
Huh?
Yeah.
From the appreciation of the entire evidence led by the parties, including the petitioner himself, as set out in the pending preceding paragraphs, it can be seen that the petitioner was assigned with the work of receiving the case diaries and keeping them in safe custody till they were required to be produced before the court as and when the bail applications were listed by placing the case diary in bail application. Therefore, in respect of the assignment given to the petitioner, there is no dispute with regard to his responsibility. The petitioner himself had admitted that on few occasions he could not send the case diaries, and for that he has offered no explanation. It therefore only appears that there is some degree of negligence on the part of the petitioner in carrying out his duties and responsibilities. For the action or inaction of the petitioner, the disciplinary authority has imposed upon him a major penalty of compulsory retirement, which was again confirmed against the appeal filed by the petitioner. It is a settled principle of law that the disciplinary authority is the sole judge of the facts, and judicial review should not be exercised to review the decisions as an appeal, but to only examine the decision-making process. Having arrived at an opinion that there was some degree of negligence on the part of the petitioner, the question would be as to whether the penalty of compulsory retirement, which is a major penalty imposed upon him, is commensurate with the actions or inactions. The same under the facts and circumstances and in considered view of this court appears to be excessive. By applying the principle laid down in the court of Deputy Commissioner, Kendriya Vidyalaya, etc., this court deems it fit to remand the matter back to the disciplinary authority to consider the penalty imposed upon the petitioner for an imposition of lesser penalty other than the compulsory retirement. Accordingly, the impending order is dispensed. And my submission before your lordship is when the charge sheet was submitted, minority, in the charge sheet, it was clearly indicated that there were interim orders in the bail, anticipatory bail applications for non-production of the case diary, which was received by him. Ultimately, the matter could not be decided on merit, it was made absolute. This is one. And in the written statement, he admits that yes, I could not produce it. He says that it was received, and the lordship in the charge sheet it is quoted what the learned single judge in the case of that bail application passed in order. Repeatedly, my lord, 4 or 5 occasions, case diaries with the office, it doesn't go to the court. And he says it is my responsibility.
What is this tractor and
Previous
farm equipment? case?
2013.
Yeah, what is this tractor and farm equipment limited versus Secretary of the Government of Assam? Judgment of a single judge can be set aside only when there is a patent error on face of the record. The judgment is against the established but settled principle.
The conduct of the delinquent, my lord, is actually amounts to criminal contempt. For his,
You are taking it very seriously.
my lord,
You're taking a minor offense on the part of your
no, my lord,
employee.
in respect of five innocent.
And what, which paragraph in Chaturvedi are you referring to?
Yes, my lord.
Why this angst against your own employees? Mr. Mazumdar,
My lord,
any personal reason? Personal in the sense, what could be the reason?
authority, disciplinary authority.
Authority.
There is no person, absolutely no. My lord,
Para 18, my lord, explain.
if it is a simple case of negligence, matter would be different.
What is this if it is not a simple case? No record has been lost, nothing has been sold in the market, no money has been extracted
lord.
on the basis of that.
Withholding,
These are case diaries or what?
my lord,
Anybody can get it.
no, my lord, case diaries are withheld for a different purpose, my lord.
Paragraph? Which paragraph are you?
18, my lord. Basic hole बहुत কথা বলা the inquiry officer, the presenting officer, all the khaki ki hote what is the evidence? It is no evidence.
Madam, as far as I'm concerned, my
In fact, it should, to shorten the litigation, the court itself should have imposed appropriate punishment. But a safer course was adopted by the learned.
My lord, I am not arguing.
I'm very sure
relying, my
that
lord.
if I had heard it, I would have decided to shorten the litigation. And of course, that's subject to further review by superior court. But then, I mean, this is not an offense which shocks. It does shock my conscience with
Otherwise,
otherwise it.
My only more or less lordships have decided. I can.
No. We speak under our mind. These
My
are tentative observations,
My lord.
Mr.
My lord, what I'm trying to say, what I find from the record, my lord, there is a charge sheet specifically saying that for days together, case diary has been received. Ultimately, the IO had to come, pursuant to an order passed by the court in the bail application. He comes and says that I sent the case diary on the very first day.
Give him any punishment less than let him remain in service. Don't starve him to death.
And that
We
is
will-
what
we will
Honorable
uphold.
Single judge has said.
We'll uphold it. If this does not shock anybody's conscience, what would?
In fact, it's
There
character.
are,
He's
there are
choosing-
so many.
will be-
Look at the way in which the officers behave. He is a clerk.
No, but he has the responsibility of receiving the case diary and sending it to the court.
Where is the evidence in the entire record that it was done deliberately for a purpose?
Yes.
For helping somebody,
My-
or for I mean, not permitting bail order to be granted.
My lord,
Where is the evidence?
in his written statement, he admits.
Therefore, if there is no evidence for any other extraneous purpose, then it is negligence. And if it is negligence only, then you don't
Extreme punishment.
you don't use a sledgehammer to kill a fly, do you, Mr. Mazumdar? मच्छर मारने के लिए आपने बम का प्रयोग
Sometimes when machers bite in
they
such
cause
a way.
malaria.
Yes, machers bite causes malaria. That is what my lord.
I thought that you will withdraw this appeal. Anyway, take it. पहले इनकी अपील लिखते हैं. WA number 46 of 2025. The state has preferred an appeal against the judgment and order dated 12/9/2024, passed by a learned single judge of this court in WPC number 4258 of 2023, whereby the case of the respondent has been remanded to the disciplinary authority for a relook at the punishment awarded to him of compulsory retirement for the reason of it being excessive and disproportionate to the guilt to the guilt alleged and proved. The respondent at the relevant time worked as junior administrative assistant in the office of Senior Government Advocate Assam, Guwahati High Court. The charge against him was that he did not produce the case diary in the bail application. This charge was not with respect to any isolation. This was not an isolated instance of negligence, but case diaries in about 4 cases were not tagged with the bail application, which was one of the duties of the respondent. The respondent therefore was charged of gross misconduct, negligence of duty and breach of trust, thereby bringing disrepute to the institution, that is the office of the Senior Government Advocate, and violation of Rule 3(1) of Assam Civil Services (Conduct Rules 1965. In the domestic proceeding. Five witnesses were examined on behalf of the department. In defense, the respondent got himself examined and one Kamal Kumar Nath, his contemporary in the same establishment, the charges against the respondent were said to have been true. It was before the court below. No, not below. It has been argued on behalf of the respondent. It was argued on behalf of the respondent before the 11th single judge that though the case diaries in some of the bail applications could not be attached, but it was not with any malified intent. In one of the cases where the case diary was not supplied, the cover of the file gave an impression that the application had already been disposed of. For this reason, that particular file was kept in the disposed section. The respondent was also transferred from the criminal section. And therefore, he was divested of the responsibility of tagging the case diary to the bail petition. That apart, it was argued on his behalf that he was only one of the junior assistants in the establishment, and therefore the entire blame could not have been foisted on him. Be that as it may, the learned single judge, no, उसको हम बीच में छोड़ दिया ना, no, उसके ऊपर लिखना, the charges were proved. The respondent was punished. The respondent was saddled with the punishment of compulsory retirement, and the appeal against such order was also dismissed. Before the learned single judge, it was argued. Before the learned single judge, it was argued. Be that as it may, the learned single judge, on having gone through the records, observed as follows: paragraph 41 of Code 41 of the judgment of Code. Paragraph 41 and 42. A reading of the aforementioned two paragraphs of the aforementioned two concluding paragraphs of the impugned judgment, it clearly appears that the punishment of compulsory retirement for a venial offense of not tagging the case diary in 4 bail applications was found to be totally disproportionate and not sustainable in the eyes of. There is a clear indication in the aforementioned two paragraph that the sentence of compulsory retirement for a charge of this nature was shocking to the judicial conscience, especially in the absence of any evidence to suggest that the case diaries were not supplied for any malified intention or for the purposes of helping somebody or for deflecting the course of justice in any manner whatsoever. In our estimation, this is nothing but negligence, which did not demand the punishment of compulsory retirement from service. The learned Mr. Mazumdar, learned advocate from the appellant. ऊपर में सब लिखते हैं ना, Mr. Mazumdar, learned advocate from the appellant has submitted that 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 the offense was not, the offense is not, the charge is not venial, but very serious. And it had the potential of deflecting the course of justice. First of, seen in that background, the punishment of compulsory retirement cannot be said to be shocking to judicial counsel. First of, in that case, the remand of the case to the disciplinary authority for having a relook at the sentence was nothing else but substitution of the view of the disciplinary authority with that of the learned single judge, which is not permissible. ANI argument, this is your, which is not permissible. On the contrary, Mr. K. Chaudhary, learned senior advocate for the respondent, defends the judgment impugned by reiterating that from the records, no guilty intention could be deciphered. Guilty intention could be deciphered. On the paragraph, on the paragraph. Which paragraph you had read from Kendriya Vidyalaya?
Myself, my lord.
Kendriya Vidyalaya.
Para 8. Para 8. Yes, paragraph 8, madam. Kendriya Vidyalaya.
We have examined the records of the case. The remand by the learned single judge is only for a relook at the punishment imposed by the disciplinary authority and to consider whether it was reasonable for such punishment to have been settled for the charge. For the charge. The learned single judge, applying the principle of Ranjit Thakur versus Union of India, 1987, 4 SCC 611. Found that the facts of the case warranted lesser penalty. However, instead of doing it himself, he remitted the matter to the disciplinary authority for the needful, which is permissible under the law. In BC Chaturvedi versus Union of India and others, 1995, 6 SCC 749. It has been categorically held that the High Court, it has been categorically held that the law on the subject has concretized and the appellate authority has been concretized that the disciplinary authority is invested with the discretion to impose appropriate punishment, keeping in view the magnitude or gravity of the misconduct. The High Court, while exercising the power of judicial review, cannot normally substitute its own conclusion on penalty and impose some other penalty. If the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the High Court, it would appropriately mold the relief, either directing the disciplinary authority to reconsider the penalty imposed, or to shorten the litigation, it may itself, in exceptional and rare cases, impose appropriate punishment with cogent reasons in support thereof. In Ranjit Thakur Supra, it has been clarified that the question of the choice and quantum of punishment is within the jurisdiction and discretion of the disciplinary authority. But the sentence has to suit the offense and the offender. It ought not to be vindictive or unduly harsh. It should not be so disproportionate to the offense as to shock the conscience. As that itself would be a conclusive proof of bias. As bias. We are of the considered view that the punishment imposed upon the respondent was excessive and deserved deference. In this case, the learned single judge has rightly remanded the issue to the disciplinary authority. We find no reason to interfere with the decision of the learned single judge. While saying so, we are also reminded of the wisdom. We are also reminded of the caution sounded in Tractor and Farm Equipment Limited versus Secretary to the Government of Assam, Department of Agriculture and others, 2004, 2, Guwahati Law Reports 56. That a writ appeal is an appeal in principle. But unlike a criminal appeal, where the whole evidence on record is examined afresh by the appellate court, in writ appeals, what is examined is the legality and validity of the judgment and order of the single judge. Such judgment could be set aside or interfered with only if there is a patent error on the facts of the record, or the judgment is against the established or settled principle of law. If two views are possible and a view, which is reasonable and logical, has been adopted by a learned single judge, the other view, howsoever appealing, ought not to weigh with the division bench in setting aside the judgment by the single judge. For the reasons referred above, we are inclined to and dismiss this appeal. This appeal will be for Abdul Quddus Smith. After some arguments, Mr. Ken Chaudhary, learned senior advocate, seeks permission to withdraw this appeal. Dismiss has been.
Lord, there is one technical problem. I've discussed with my learned friend also. Now the disciplinary authority was the inquiry officer. So in that view of the matter, whether your lordship should consider having regard to the facts of the case to pass an appropriate punishment.
No, that we don't do. Therefore, tractor farms, we have said. Anyway, we would have, we said upfront that I would have lessened it to, reduction in salary or something.
Something.
And not even cumulative. Every day it happens in a lawyer's office.
Milord, what I am saying, so
No, Milord,
there
in
will be some
this case,
technical.
it has been,
One day,
it has
No,
been
otherwise I would not have
happening
made this
repeatedly.
argument.
now that the matter is over, let me tell you one incident from my life.
my lord.
I had completed 10 years of practice, and one day I rushed to a courtroom. The judge was, the division bench was rather strict with the lawyers. And that bench would brook of no laxity on the part of a lawyer, and they had a very harsh tongue. So I rushed because I saw that on the board that my matter was reaching. I rushed there, thinking that my clerk is running behind me with the file. And when I go there and stand before the judges, he is not to be found. He was not there. I don't know what kept him back. So the judge started shouting at me, said that this matter is, as this matter was called out, it was called out twice, thrice, then you appear. This is how you treat the court, something like that. I said sorry and all that. I came out, I was so angry with my clerk that I just asked him to go away. I said that you hand over all the file and leave my office straight away. No, somewhere near where I said that, my father was there. He was also a lawyer that time. He said that, what are you doing? What is this? Many a times we do. Many a times you as a junior would not have brought the relevant book. Now, does it mean that your license be cancelled? Now, these are real wisdoms from the life. You can't possibly do like this.
Therefore, my lord, states should have a litigation policy.
Although that's a bigger
And
thing.
only
But even say in a private office, in a private lawyer's office, do you always find your clerk to be compliant?
All that we do is we scold them,
Even
Milord, and
juniors
forget
do
after
it.
5 minutes.
My lord,
At least you can shout.
my
You can
lordship,
shout, you can throw the
I'm
file.
in the habit of that, Milord. But after 5-10 minutes, I forget.
my lord, these observations, your law.
Look at the level at which he was working. I mean, if you take him out of job, his entire family suffered.
That is the, otherwise I would submit, my lord. It is true that in the disparity, even the chart, so for now that your lordship has already passed the order, I can just, in the chart, there should have been one more chart that there was, mens rea was there.
But you had to prove it, no?
My lord,
merely
my
by
lord,
chance.
my
it
lord,
would not have-
they should have gone, because in this case, it has been happening repeatedly.
learned
4 cases they have identified.
I tell you, frankly, I have
My
there is no hide and seek.
My lord, yes, that's what I'm
If I would have heard it, I would have lessened the punishment myself. Applying Ranjit Thakur
saying.
Yes.
straight away.
My, anyway.
All right, Mr. Mazumdar, you have argued more than what
Is